Mr. Nelson? Is he going to be out still? Okay.
He's speaking with Dr. Bowden.
Okay. Well, we'll wait for Ms. Johnson. I mean, are you ready to proceed? Yeah, okay, go ahead. Just let me know when you're in there.
Your Honor, I apologize for the delay.
No problem.
And then the courtroom doors were locked, so they have locked me out.
Okay, we're waiting. Actually, we're not really waiting on you. We're waiting on the jury. They're bringing them up.
Okay,
I guess,
yes,
are
sir.
they in yet? Okay, jury's ready then. Now I'll ask again, are we ready for the jury? Oh, they're still on the way up, okay. Mr. King, could I speak to you just a second? It's a totally housekeeping matter here.
That's fine.
I think that's something.
Yeah, thank you.
We got a jury ready? Okay, we'll be in informal recess then for a few minutes until we can find us a jury, so. Very good. Thank you, sir. Be seated, please. Good morning, members of the jury. We are getting a little later start than we had hoped, but we've accomplished a great deal in your absence. Let me say that. I do need to tell you, you may notice defense counsel is missing Mr. Nelson. He's still here. He just wanted me to make sure that everyone knew that he hadn't run off, so to speak. But he's taking care of some other matters. He may appear shortly, or he'll be in and out. So having said that, is the defense ready to proceed?
Yes, Your Honor.
Would you call your next witness, please?
Dr. Brian Cahill.
Okay, so before you sit down, if you will raise your right hand and face the clerk, and she will administer the oath.
Do you solemnly swear or affirm that the testimony you will give will be the truth and the whole truth, so help you God?
I do.
Have a seat, please, sir, and I'll ask you to sit up close to the microphone, adjust it so that you can speak into it.
Okay, thank you.
And then I'm going to ask you to state your name and then spell your name for the record, please.
All right, my name is Brian Cahill, Brian Cahill.
Thank you, sir. Counsel?
Good morning, Dr. Cahill.
Good morning.
Could you please give the jury a summary of your educational background?
Sure. So I earned my bachelor's degree in psychology at Illinois State University in 2005. I received a master's degree in experimental psychology from University of Colorado Springs in 2008, and then a PhD in legal psychology from Florida International University in 2015.
What is your current profession, Dr. Cahill?
I'm an associate instructional professor at the University of Florida.
And how long have you been a professor?
I was hired there in 2016. And then before that, I was an adjunct professor at Florida International University for, I think, 3 or 4 years, something like that.
So how long have you been a professor?
About a decade now.
And what classes do you teach at the University of Florida currently?
So I regularly teach cognitive psychology, legal psychology, research methods. I've taught social psychology there and introductory to psychology, and I teach sensory processes every once in a while as well.
Have you testified in a court of law before?
I have. This, including today, is my 7th time, I believe.
And in what field do you consider your expertise?
So I'm a legal psychologist, which means it's a fancy way of saying I'm a social cognitive psychologist that applies that area of psychology to the legal system. Specifically, I study memory and decision making, particularly in a legal system avenue.
And speaking of memory, do people often hold false beliefs regarding memory?
Yes, they do.
Could you give the jury a couple of examples of false beliefs related to memory?
Sure. So 2 of the most basic findings from memory research comes back to Herbie Ebbinghaus, who's the father of memory research, is the exposure time, which is the idea that the longer time you have to view something, you'll remember more information. About 30, let me look at my notes real quick, 39% or something around there get that question wrong. And then forgetting curve is another one. So forgetting curve is the idea that what we find is that you forget most of the information of an event, or not most, but a lot of it right after the event, and it slowly tapers off. So after a while, what gets into your memory is generally there for a while, but we do forget a lot quite quickly after the event. And about 35% or somewhere around there, people get that idea wrong as well.
So when you say people are getting that idea wrong, is it fair to say that people believe that you remember more than you actually do immediately after an event?
I'd say yes. So, and I'm talking about people who don't study this for a living, right? Laypersons. Related to that is another finding that laypersons typically believe that memory works like a DVD recorder, that we simply record everything that we encounter and then we store it as is, and we can just recall it later on. If you've seen the movie Inside Out, it kind of represents that when they bring up the orb, in the brain with joy and whatnot. That's not how memory works. Memory is more like a Wikipedia page where you can go in and edit your own memories, and so can I. So it's not as accurate as some people believe it to be.
And can you explain to the jury what the difference is between retrospective memory and prospective memory?
Sure. So there's a few differences, but the main one that we care about is that the retrospective memory is remembering events and information from the past, and prospective memory is remembering to do something in the future. So prospective memory, think of it as more action-based. I have to remember to buy milk on the way home when I leave work, something like that. Whereas remembering my son's name is a retrospective memory. Remember playing with him last night is a retrospective memory, something like that.
And Dr. Cahill, I got a little ahead of myself. May I approach the witness, Your Honor?
You may.
Thank you. Cahill, I'm showing you what's previously been marked as Witness Exhibit B. Could you look at that, please?
Sure.
Do you recognize that?
It looks like my current CV.
And could you explain to the jury what a CV is?
It's my resume, basically.
And is that a fair and accurate representation of your education, your work, your writings, and other things associated with your profession as a psychologist.
Yes.
Your Honor, I will seek to move this in as Exhibit 1.
Any objection?
Objection.
Very well, that will be received as Defense Exhibit 1.
Thank you, Your Honor. So Dr. Cahill, going back to the retrospective versus prospective memory, retrospective memory, I think you said, is remembering things that have happened in the past or recalling information that you need, correct?
Correct.
And then prospective memory, could you explain that one more time for the jury, please?
Yeah, so prospective memory is remembering I have to do an action. I have to complete some task in the future. So, yeah, go ahead.
Does prospective memory usually have two parts?
Yeah, so prospective memory in general is a task demanding process that you engage in, because you're having to do everything you're doing while you're trying to remember that I have to do this in the future, right? So I'm sending emails or working on something knowing that at some later point in time I have to do another task, right? So there's typically two parts to a prospective memory task. The first part is remembering that I have to do something, and then the second part is remembering what that was I have to do.
And are there different kinds of prospective memory?
So there's two main types, which is called event-based and time-based. So event-based would be I have to remember to buy milk on the way home. That would be an event-based one. Time-based would be I have to remember to go to the doctor at 3 p.m.
And how long has science or psychology studied prospective memory?
So we've talked about it in various ways since early 1900s, but with the term prospective memory and more focused study, about 1977 was when the first paper was done looking at prospective memory. So about 50 years ago now.
Would this be considered a well-established area of or field of study in psychology?
I would agree with that. Pretty much any introductory psychology, cognitive psychology textbook I've ever read has a chapter or information on prospective memory. I teach it every semester when I teach the class. Memory books and memory improvement books will have an entire chapter usually on prospective memory. Thousands of articles and stuff has been published on it. So I'd say it's generally accepted, yes.
And is the large majority of those articles you mentioned, have they been peer reviewed?
Yes, so if you just look at peer reviewed, I did a search a week or two ago. And when you just look for peer reviewed articles in my largest database with prospective memory as a subject term, about 2,800 of those hits are peer reviewed papers.
Could you explain to the jury what peer reviewed means?
Peer reviewed is I do a study or write a paper, and in order for me to get published, I have to have my peers who are experts in the field approve of my work, basically. Make sure it's valid and the methodology used is sound. So the conclusions I'm drawing are good. So we have good science.
So we've talked about the fact that prospective memory is basically the idea that you have to remember to do something in the future. Are there ever errors with prospective memory?
There are.
And when we say errors of prospective memory, what are we talking about?
So first off, I'd like to explain that, again, prospective memory is a hard process for people to do, relatively speaking. Our brains work really, really well. And all of us in the room are listening, and we're trying to use our previous knowledge to understand what I'm saying. You're taking notes and whatnot. All of this is kind of done effortlessly. So we think that, everything we do is kind of really easy with our brain, but the brain's actually doing some really cool stuff right now. So when we're trying to remember to do something in the future, you're having to process the environment that you're in and remember to do this task. That's very cognitively demanding. And we only have so many resources in our brain to do some things at once. We've all experienced a failure when we try to do too many things at one time. So think of it in general, the more taxing I make a situation, anything I do to draw resources away is going to increase the likelihood that I make this kind of error, this prospective memory error.
And is a prospective memory error basically forgetting what you had planned to do in the future?
So there's two types. There's the experience where this is the less common one from the research, which is where I show up to the store and I say, I remember my wife told me I had to get something, but I just can't remember what it was. That's the first type. That's not as common. The second type is forgetting simply overall that I needed to do something. So I simply drive right by the store and go home. And then obviously my wife gets mad at me and tells me I have to go back to the store to get whatever she wanted me to get.
Have there been studies that have been conducted in the scientific field that discuss how often errors with prospective memory occur?
There have been.
Could you give the jury an example of one of those studies and its findings?
Yeah, so there's kind of a couple of different ways we can look at this. One is through diary studies. So we have participants keep a diary of their daily events for weeks or a month or whatnot. And then we have them write down, in this study, they had them write down any kind of memory error that they made, right? And then we coded that data later on. So like these could have been a retrospective error. I forgot someone's name. That would be a retrospective memory error. Or it could be, I forgot to turn in my paper for class. That would be a prospective memory error. And when they code this data of the memory errors people make, prospective memory errors are the most common form. They're about 50 to 80% of the time that someone makes a memory error, it is a prospective memory error. And then there's other research that looks at same kind of thing with diaries, and it has people write down how many events that they had to do that week. So in a given week, maybe someone had, I think it was on average about 13 things they had to do that week. So tasks in the future they had to complete. And then they had to write down like how many of those did you complete? How many did you not complete? And then of the ones that were not completed, they asked them, why wasn't it done? And of those 13, I think it was about 13% of the time, people forgot to do the task. That would be a prospective memory error. There was other reasons why they didn't complete the task. They rescheduled the appointment or they canceled it. Those are not prospective memory errors because they remembered that they had to do it and then they took care of it. So we really focus on the ones that were forgotten from that list, which is about 13%. And then, sorry, one more thing. There's also some survey research where they've asked parents of young children, how many times have you ever been driving and forgotten that your child was in the car at some point? And about 25% of parents report experiencing that at some point while they're driving their car with a young child in there.
Thank you. As you're talking about these prospective memory errors or the lack of remembering, are there factors that have been researched that have been determined to increase the likelihood that one of these errors would occur?
There have been.
Can you describe briefly what those factors are?
Yeah, so there's generally kind of 6 categories of these. And again, think back to what I explained earlier, that all of these are going to affect your ability to process what's going around because they're gonna draw upon resources in your brain. Okay, there's 2 kind of global ones, and that's sleep, lack of sleep disturbances, and stress, overall chronic stress. Those things are generally going to affect prospective memory. And then the other ones are more situational type of things, lack of retrieval cues, multitasking, divided attention. And then we have, hold on real quick. Divided attention. Let me look at my notes really quick, sorry.
Dr. Hale, if I
Yeah.
will, I'll ask you a question.
Yeah, sorry.
Is it, are there also factors such as variations from your usual routine that can affect or cause prospective memory errors?
Yeah, violating your routine.
What if you, would you consider being rushed or in a hurry a violation of your routine?
Yes.
Any other factors that you can think of that may affect someone or increase the likelihood of a prospective memory error?
Yeah, if I can look at my notes really quick, just to make sure. So those are the ones that I can think of right now.
We talked about prospective memory errors, and you mentioned things like, I forgot to stop at the store to get the milk, or I forgot to do this, and instead I went directly home. Those are pretty minor forgetfulness things. Is it possible for a prospective memory error to lead to catastrophic results?
Unfortunately, yes.
And could you describe for the jury some of the studies that have analyzed prospective memory errors that led to catastrophic results?
Yes, so there's several that we've applied it to. I'll talk about mainly airplane crashes. So one study got a hold of records for airplane crashes and looked at 75 of them to code what was the main cause of that crash. And 74 of the 75 were traced back to a prospective memory error of some kind. The other type was a retrospective memory error. So 74 of the 75 crashes were mainly caused by a prospective memory error.
So does that mean that someone, the pilot or someone, forgot to do something that they should have done in order to maintain the craft safety?
Correct. So in one example, the landing gear was not lowered because they were distracted doing something else while they were going through their checklist.
You mentioned checklists. Would the checklist be one of those retrieval cues that you would ordinarily think would help prevent a prospective memory error?
Yeah, so often we know because of the research that these can be catastrophic in these kind of situations with airplanes specifically. So they have checklists and they have default things that pilots must go through, checklists to kind of make sure these things don't happen. And unfortunately, no matter what you do, we are human and these things can occur even with the most due diligent person thinking ahead, having a checklist for pilots. We still have accidents. Even though it reduces it, we still have them.
And do prospective memory errors occur in other occupations?
They do. They've shown them in surgeries. Doctors have forgotten to remove surgical equipment from people, sewed them up with surgical equipment inside. Police officers going to the bathroom at movie theaters have forgotten to get their gun after they've taken it off to go to the restroom. Pharmacists have made errors, giving out medication. You can go on and on. Any job that a human's working, you're going to have prospective memory errors.
When a person commits a prospective memory error, according to the research, do other people tend to attribute that to a dispositional factor or a situational factor? And before you answer that, please explain to the jury what I mean between dispositional and situational factors.
Sure. So think dispositional as character, and then situational as the environment. And then to answer your question, I would say, yes, there is research to look at that. And I would say based upon the research, people tend to attribute behavior, prospective memory errors to a dispositional factor rather than a situational factor.
And is that something that is studied in the field of science and is known as the fundamental attribution error?
That is correct.
Is that fundamental attribution error also a well-accepted concept in the field of psychology?
That is correct. Any social psychology class you take, any introductory psychology class you take is going to discuss the fundamental attribution error.
When people are analyzing or looking at other errors that people have made with memory, do the studies show that people tend to think that those sorts of things would never happen to them, or that they couldn't commit that kind of error?
I would say yes.
Could you give the jury an example of the fundamental attribution error and the dispositional versus situational concept so that it's more clear to them?
I'm sure. So we've all experienced this. You're driving down the road and someone cuts you off. You may immediately kind of have that gut reaction of, oh, they're being inconsiderate. They're just cutting me off and they're not being nice about it, right? Instead of thinking about, well, maybe they're hurt and they're trying to get to the hospital, or their wife's giving birth, or whatever the case is, right? We would tend to jump to the conclusion that they're just being that way and that's who they are, versus the situation's driving their behavior more so.
We talked about the factors that have been shown by the research to increase the likelihood that a prospective memory error would occur, and you went through several of those. Have you had an opportunity to learn of information related to this case?
I have.
And did you, through your analysis, apply those factors or look for those factors in the case of Rhonda Jewell?
Yes, I did.
What information were you provided related to this case?
May I look at my notes for that?
Yes, please.
So I read the deposition of Brooke Page. I read the deposition of Stacy Pascal. I read the police report. I watched the interview of Rhonda Jewell, and I looked at some text messages that I received.
And in applying these factors to Miss Jewell's case, let's go through them one by one, if we may.
Yes,
You mentioned that one of the big factors was sleep or sleep issues. Was that factor present in this case, to your knowledge?
not to my knowledge, no.
What about the multitasking or divided attention?
Yes, that was.
And specifically in your analysis of the case, what sort of things are you talking about in that Miss Jewell's attention was divided or she was multitasking?
Sure. So driving in and of itself is multitasking. So you're driving and you're at the same time trying to remember other things you have to do throughout the day. You're trying to make sure you don't get into a car accident. You're trying to see what the time is. Am I running late? All those kind of things. So that's all multitasking. Once she got to the house throughout the day, she's multitasking. She's babysitting 3 kids. And from what I read in the deposition, she was very attentive with the children. She played with them. So that's multitasking throughout the day, and that's going to continue that that factor beyond the, yeah.
What about changes in the routine?
Yes, that's a big one, yeah.
What sort of changes in the routine were you aware of in this case?
So from my understanding, this was not the normal way for her day to start. It wasn't normal for her to have a RIA on this day. The schedule changed quite frequently. So that would throw things into a realm of increasing prospective memory error.
If it were normal for her to have a RIA on this Wednesday, but the timing was off, would that have increased prospective memory error occurred?
Yes, that's still throwing off the routine, yeah.
What if earlier in the week, hypothetically on Monday, she had a RIA, but not the other children of Stacy's, which was a non-usual change? Would that have increased the possibility of a prospective memory error?
Based upon the empirical data, yes.
One of the things that you talked about was the lack of retrieval cues. You said that you mentioned that you saw some text messages related to this case. Specifically, I believe you saw the text messages between Rhonda Jewell and Brooke Page. Is that accurate?
Correct.
And I believe you were also provided a copy of the Snapchat message between Rhonda and Nevaeh Carter. Is that also correct?
Yes.
Usually, would you expect these text messages of this type to be a retrieval cue for a RIA?
I'm sorry, can you repeat the question?
Would these text messages have been a retrieval cue for a RIA, in your opinion?
I would say, in my opinion, they would not be a good retrieval cue for a RIA.
And why is that?
A RIA was not mentioned in the text messages or the Snapchat.
If it were evident that Brooke Page and Rhonda Jewell texted on a very frequent basis, would that decrease the likelihood that these particular texts would be a retrieval cue?
Absolutely.
Same question with regard to Nevaeh. If it were evident that Rhonda Jewell and Nevaeh Carter texted often or communicated often, would that decrease the likelihood that this Snapchat would be a retrieval cue?
Absolutely. As an example, if my son's grade school or daycare teacher texted me, the only time I talk to her is with my son in the context. So that would be a good retrieval cue. But if I talk to her every day about many, many other things, or not necessarily just every day, but regularly, that would not necessarily serve as a good cue for my son.
What about other retrieval cues? Was there generally a lack of retrieval cues on that particular day related to a RIA?
Based upon my review of the evidence, there were a lack of retrieval cues, yes.
And can you give the jury an example of what some of those may have been?
So a couple. So the diaper bag was in the back seat when she was driving, my understanding. And then when she got to the house and went inside, the diaper bag was still in the car. So there's no reminder of Araya at the house when she was inside babysitting. Miss Pascal, and I believe the daughter, I don't remember the daughter's name off the top of my head, but they did not know, if I remember correctly, that Araya was going to be there that day, so they didn't ask her. Usually they, from my understanding of the depot, they were very excited to see Araya and they would want to play with her and interact. And they didn't know she was coming that day, so they didn't do that. So those are two examples of that. And in general, retrieval cues are very, very, very important for memory. They may be the most important thing to trigger memory.
And I would assume that the studies would show that the stronger the retrieval cue is, the more likely is that it would trigger memory.
Correct. And then, yeah.
Does the factor of Rhonda Jewell's attention being divided and her being multitasking make it more likely that a prospective memory error occurred on July 19th?
Yes, it would.
Does the factor of lack of retrieval cues make it more likely that a prospective memory error occurred?
Yes, it would.
Does the factor of the changes in the routine of who she's keeping, when she's keeping them, where she's keeping them, does that factor make it more likely that a prospective memory error occurred?
Yes, it would.
If more than one of these factors is present, does it make it even more likely that a prospective memory error occurred?
Yes, it would. So in general, when you add these factors, they will exacerbate or make it more likely that something would happen. Let me give you a lay person's example for that, because that can be hard to understand. Let's take a hurricane. If we have a lot of wind, right, the chances of a tree falling down is good, but add 3 inches or 3 feet of rain on top of that, it's way more likely that the tree is going to fall down with the wind, right? That's what's happening here. You're adding one factor that increases the likelihood of the tree falling down, and you exacerbate that by adding this, and this factor. It creates a perfect storm for something like this to happen.
Dr. Cahill, if Miss Jewell remembers picking up the child on July 19th, remembers driving down the road, remembers that she considered stopping for breakfast for the other children, remembers driving on a state street, would that invalidate the statement that she forgot the child was in the car?
In my expertise, no.
Why not?
Goes to credibility, vouching. Sir?
Go ahead, I'm sorry.
Oh, sorry, vouching for credibility is objection.
Okay, I'll overrule that.
You can answer, Dr.
Okay.
Cahill.
Let me gather my thoughts. So one thing, retrospective and prospective memory are two separate tasks. In general, we have a lot better retrieval cues for a retrospective task. By definition, when you're doing a retrospective task, for the most part, you're being asked, do you remember X? That fact right there is a retrieval cue. So it's going to help you remember that. Two, Miss Jewell has retold this story to police, to lawyers. She's run it over in her head, I would imagine, thought about it a lot, recalling those over and over and over again. That's going to strengthen a memory. Anything you think about a lot generally will create a stronger memory trace, so you'll remember it better. That does not invalidate the fact that you could make a prospective memory, or you could certainly forget to do that and then remember everything else along with that. Just like when people recall memories in general, just because their reports are not consistent doesn't mean that they're inaccurate. That's how I'd answer that.
So does the fact that she remembers today those things using her retrospective memory mean that she couldn't have forgotten the child in the car?
Absolutely not.
So if you have a prospective memory error, does the person usually forget everything that's going on at that time, or just particular tasks?
I would say generally, no, it's the prospective memory error is forgetting to do that task. It doesn't mean that they are unable or not encoding the other things that they're doing at that time.
The
In fact, maybe, I'm sorry to interrupt you. In fact, the more you're paying attention to what you're doing at that time may lead to even better memory of that, because you're giving your resources to that task and paying attention to that. So that could actually lead to better memory for what you're doing while you're forgetting to do something that you plan to do, if that makes sense.
So is it fair to say that what you mean is that the more focused you are on the other things, it's potentially more likely that you're going to forget the task that you have to remember in the future?
Yeah, because again, remember, prospective memory is a complex cognitive process that requires a lot of resources, and you're devoting those resources to instead to that to do this other thing. It's not a conscious choice that you're doing that. You're just doing the task at hand. You're doing whatever you're doing now. And the more you do that, the more you pay attention to something, generally speaking, you're going to recall it better, the exposure time, basically.
If someone is extremely diligent, is there ever a time when prospective memory errors are always avoidable?
No, it's impossible. Even, I mean, like I talked about before with airplane pilots, surgery, I mean, we set things up because we know these errors are going to happen. Myself, I'm a memory expert. My wife never forgets to give me a hard time when I forget to do something that she told me to do, and brings up the fact that you're a memory expert. I thought you would never make this mistake. So no matter how diligent you are, we are going to make these kinds of errors. You can set up all the reminders you want necessarily. There can be situations when they don't occur. For instance, I had a reminder the other day to email a student. And at that time, the reminder went off. A student walked into my office and got me distracted. I had to help that student, and I forgot to email that student back. So
The factors that we've talked about today that have been scientifically shown to increase the likelihood of forgetting something or a prospective memory error, the multitasking, divided attention, being hurried, lack of retrieval cues, changes in routines. In your professional opinion, do they support Rhonda's statement that she forgot Araya was in the vehicle?
yes, I would.
I have no further questions for the witness. Tender. Thank you, Dr. Cahill.
You're welcome. Thank you.
Cross-examination?
Thank you, Your Honor. Morning, Dr. Cahill.
Good morning.
You're a lecturing professor at the University of Florida, is that right?
My title is an associate instructional professor.
And you did your dissertation on eyewitness choosing behavior, the role of ekphoric experience and non-memorial cues.
That is correct.
You did your master's thesis on the prevalence of ADHD, its subtypes, and comorbidity in adult prison inmates.
That is correct.
Looking over your CV that was introduced into evidence, it looks like you've done some professional peer-reviewed journals on witness accuracy in lineups. Is that correct?
Correct, among other things, yes.
Among the other ones, neuroimaging evidence of mock juror decisions,
Yes,
personality disorder profiles of incarcerated male rapists and child molesters.
correct.
You've given professional talks to the Florida Association of Criminal Defense Lawyers. Yes?
Yes,
And wrongful conviction speaker series. You spoke there as well.
I believe that one, I organized that one. I can't remember if I actually spoke, but I organized one. If you're talking about the one at University of Florida, yes.
Prior to today, in this case, you've never testified about prospective memory in court. Is that fair to say?
That is correct.
Now, prospective memory, as you testified on direct, is talking about forgetting to do something you intend to do in the future.
Correct.
A fair way of saying it.
Forgetting to do something that you intended to do in the future, yep.
So I have two daughters. I always plan to remember their birthdays. If I forget their birthdays, that's an example of this prospective memory error.
Correct.
So this is something that is everyday life for every human being on the planet.
We all make these errors. Everybody in the courtroom can understand, know that we've made these errors, yeah.
So this isn't a medical affliction or like, it's not amnesia or a stroke.
No. It's a result of normal cognitive processing, if anything.
Normal everyday life.
Correct.
I want to talk a little bit about the retrieval cues that you discussed with defense counsel. You said there were 6 categories, I believe, and correct me if I'm wrong. You said sleep, lack of sleep, stress, retrieval cues, multitasking, divided attention, and then violating a ritual routine. Is that correct?
Correct. Yep.
So let's go through those. Lack of sleep, you said that didn't apply in this case, right?
Not from the information I was provided. No.
Okay. Stress. All people deal with stress. Is that a fair statement?
I don't know if all people deal with stress. People have stress. Everybody has stress. Yes.
Fair way of saying it. Now, retrieval cues. Example of a retrieval cue would be what? You gave some examples, but what would be the retrieval cues in this case?
For example, the diaper bag, or Aria's diaper bag would be an example.
And you said that diaper bag was not a retrieval cue in this case because why?
It wasn't a retrieval cue because when it was from my understanding, it was in the back seat of the car when she was driving, and then she went inside. So she may not have seen it there. And then when she's inside, she didn't take it inside. From my understanding, in their police report, I think it was that it was still in the back seat of the car, so it wasn't in the house with her throughout the day.
So you would agree with me that the defendant in this case could have taken the diaper bag and put it in the front seat if she was concerned about forgetting the child?
I don't know if I would agree with concern about forgetting the child. I would say she could have put it in the front seat instead of putting it in the back seat, but I don't know her motives behind that.
Dr. Cahill, what about a blanket? Would a blanket be a retrieval cue?
If it's Aria's blanket and it's, very related to her, then that could be a retrieval cue, sure.
Like this blanket?
I don't know. I've never seen it before. I mean, if that's Aria's, so if that's Aria's blanket and that's associated with her and that was with her all the time and they knew that and Mrs. Jewell knew that, then that could serve as a cue, yes.
So the defendant in this case could have put that blanket in the front seat to remind her.
She could have, yes.
How about the defendant seeing the victim's mother? Would that be a retrieval cue?
Seeing her mother, it depends on the context. I assume she sees her other times when Aria's not around, so.
How about if their habit and routine, every time the defendant watches Araya, she picks Araya up from her mother? Every time, that's the way it happens.
So you're talking about Brooke. So every time, can you say that again?
Yeah, if the victim's mother, Brooke Page,
Mm-hmm.
and the defendant see each other, every time that the defendant watches Araya, would that be a retrieval cue, seeing Brooke?
If that's, yeah, that could be, yeah.
So if the defendant saw Brooke the morning of July 19th, that would be a retrieval cue that would link with watching the child.
Can you be more specific? Seeing her where?
Picking up the child.
So when she was coming to pick up the child, yes, that can be a retrieval cue.
Now, with these memory failures, I want to talk a little bit about time. If I'm planning to stop and get milk, to use your example,
Mm-hmm.
and I'm driving from here to Miami, and I'm thinking, okay, I'm gonna when I get there, I'm gonna stop and pick up some milk, and I fail to do that. Versus the same scenario where I'm driving, say, 5 miles. All other factors are the same. There's a much more the probability of a prospective memory failure would be much less the shorter the drive. Is that fair?
So I would say every other condition being ideal. So no distractions, good retrieval cues, all that stuff. If you held all of that to optimal conditions, then yes, shorter retention interval will lead to less errors than longer retention interval.
Now, you'd agree with me that the categories we talked about a moment ago, the divided attention, the routine, the stress, the sleep, those are all things that the person who has the memory error controls.
No, I wouldn't agree with that.
Okay, so if divided attention, is it not the person's obligation to manage their own attention?
I have a 3-year-old, and it's impossible for me to stop him from interrupting me and doing some work sometimes. So I would say that I can't control all those factors to make sure that I have undivided attention. My son doesn't understand at 3 to not bother dad while he's trying to do something. So he's going to keep bothering me until I pay attention to him, for instance.
In that scenario, as far as your attention, you have the ability to put your attention on what's most important, right?
But no, that's my point. Like we have things in the environment that will draw our attention, and sometimes they're out of our control. I cannot turn the TV on, for instance. I could turn my phone off, but sometimes other things I can't stop. So in the instance with the student coming in my office, I couldn't stop that student from interrupting me and causing me to make a prospective memory error. I can't tell students not to come by right then. It's office hours.
So if my attention is divided on the welfare of a child and a cell phone, can I not control how much attention I place on each?
Yeah, like I said, there's certain things you can dictate which draws your attention or not, but you can't ensure that all of my attention is always going to be geared here. It's our mind wanders too. So it's impossible. No matter how much you try to focus on something, our mind after a while will start to wander off onto things. And we all experience this. You start to daydream, and then when you realize it, you're trying to bring your attention back, but you can't stop your mind from wandering at times. That's why I mean that they're not completely under the person's control at all times.
Okay, so if my obligation and my duty is to watch a child, are you saying that there's nothing I can do to make sure I'm watching that child? I can't focus my attention on that?
No, what I'm saying is that you can try to do your best there, but there are times when things in the environment will distract you or draw your attention away. Even your own cognitive system, it's limited. You can only focus and do so many things at once. You can't be perfect, is what I'm trying to say. It's impossible for anybody to be perfect. So
You'd agree with me that the defendant in this case was not perfect on July 19th, right?
yes, I would.
Dr. Cahill, you cannot say with any certainty whether there was a prospective memory error in this case, can you?
I can't get inside Miss Jewell's mind, no.
You didn't perform any testing of Miss Jewell. You didn't do any analysis of her speaking to her. Is that fair?
I did not know.
You mentioned some examples of, I think you said pilots as examples when you've dealt with studies on prospective memory.
Correct.
And you said something about pilots make checklists. Was that to prevent errors?
Yeah, from what I read in some of the studies I reviewed, they have checklists so that when they go through and they're doing something, it helps to prevent them from making errors.
Taking steps to ensure that they're doing the most they can.
Correct.
Now, on July 19th, you mentioned you reviewed some of the things that were going on for the defendant about her divided attention. What were those?
Rushing to get there in the morning, stopping at Burger King thinking that there's time and then there wasn't. Then when she gets to Miss Pascal's house, talking to Stacy, talking to or babysitting the children throughout the day.
So the first one, rushing. The defendant rushing was her own choice. You'd agree with me there?
I don't recall the circumstances of why she had to rush that day, so I can't answer that. Sorry.
You said stopping at Burger King. You'd agree with me that was her choice.
Deciding to stop, yes.
Getting out of the car and talking to Stacy, again, her choice.
Getting out of the car and going inside and talking to Stacy. Yeah, sure.
And after the defendant was there on July 19th, she received a text message from the victim's mother. And you said that would not be a retrieval cue. Why?
Because it's my understanding that they spoke regularly and that she didn't ask in the text message. I didn't see any mentioning of Aria in the message. Nothing about how is she doing? Did you get there safely? Things of that nature. She just texted her and it was something about, I believe it was Miss Pascal and the surprise of her leaving late, or the not surprise, but the sarcasm that I'm not surprised that she left late.
They have a business relationship together. The victim's mother,
Okay.
victim's mother and the defendant have a business relationship together where the defendant watches this child multiple times a week. And a message from the victim's mother would not be a retrieval cue about Aria Page.
Again, I would say it's not a good retrieval cue because they talk regularly and not necessarily always about Aria.
You said good retrieval cue. You'd agree with me it's a retrieval cue.
No, it's not a good retrieval cue. It's not a retrieval cue to recall the memory that Aria was there and that she had to get her out because they talk regularly and it wasn't about Aria, is what I'm trying to say.
15 minutes go by. The defendant picks up the child.
Mm-hmm.
The defendant goes to the house on Estate Street, roughly 15 minutes, and there's a text message. You're saying that would not be a cue of, oh, I just picked up Aria Page.
No, again, because they talk regularly. If the only way that they talk is because of Aria, like I gave the example in my day school, my daycare teacher, then that might serve as a retrieval cue. But the fact that they talk all the time and not about Aria every single time, in my opinion, based upon the research, does not necessarily serve as a retrieval cue.
May I have one moment, Your Honor? Dr. Cahill, you'd agree with me that forgetting to do things we plan to do is part of the human condition,
Correct.
and that is something we all have to try to remedy.
Correct.
The brain has limits, is what it can do.
Yes.
So would you agree with me that someone can't blame forgetfulness when they fail to uphold their responsibility?
I don't know. Forgetfulness seems to me has a connotation with it that there's intent in there. I don't know if I want to go down that road.
No other questions?
Redirect.
Thank you, Your Honor. Good morning again, Dr. Cahill.
Good morning.
Just a couple of things to clarify. The state brought up stress, and I don't think we had particularly identified stress. Were you aware of any extraordinary stress that Miss Jewell had going on at this time in her life?
I did. She had some trips planned and one of her children was moving away to college. I would consider that stressful.
So extraordinary stress.
I would particularly moving away to college. Yes, as a parent, I would be very stressed with my child moving away.
The state showed you the picture of actually showed you Aria's baby blanket. If that baby blanket were in the car seat with Aria, would that have served as a retrieval cue if Rhonda Jewell had already forgotten Aria was in the car?
No, just if she didn't see it. In order for a retrieval cue to be effective, you have to it has to be placed properly. So let me give you an example. My wife is horrible at turning off lights, drives me nuts, right? So I try to tell her, sweetie, last night we were arguing, you forgot to turn the light off, right? So what I've done is I place Post-it notes at every door, leaving any room that reminds her. That fixes the problem because it's a good retrieval cue and she's gonna see that whenever she leaves. My son took one of those down and put it down on the bottom of the baseboard. Now, even though it's there, she doesn't see it. So therefore she leaves the room, she forgets to turn the light off. It's the same kind of idea.
If Rhonda Jewell were not the person who placed Araya in the car or the backpack in the car, would she need a stronger retrieval cue to remember those things?
I would say in general, the more factors that draw upon resources in general, you need stronger retrieval cues. Weaker memories, things that are harder to do, you need better cues in general for them to work.
The state asked you a question about, well, she could have put the baby bag or the blanket in the front seat to remind her. Do people believe that they can have or create or be subject to these levels of catastrophic prospective memory errors?
Objection, Your Honor.
Sustained. The way it was phrased.
Based on your research and study of this field and the fundamental attribution error that we discussed earlier, has the study shown that people, well, what did the study show about people's thoughts related to whether this could happen to them, whether these catastrophic errors could happen?
So I would say in general, people at no fault of their own, it's a byproduct of how our brain works. We tend to be overconfident in most of the things that we do in our lives, right? There's lots and lots of research to support this. So we tend to underestimate the environment and these factors that will believe that we can overcome these things. So we may not do the things that we can do to take extra steps. And it's simply because of a byproduct of how our brain works. Take myself, I'm a memory expert. I know about these things and I still make the errors all the time. It's impossible for me to create and think of every cue I would need to make sure that I didn't commit this error. I can't think of everything in the environment that could happen. I can't foresee of every situation to do this to make sure that I never commit this error again, regardless of the significance of it. If it's forgetting to buy milk, which is obviously not significant, or forgetting a ride in the car, which is a very significant event. I can't think of everything that would stop me from making that error.
You mentioned that the pilots have checklists. Those checklists are there to encourage them to follow them so that there's not an error.
From my understanding, yes.
If a person, based on your knowledge of this field, if a person hadn't had this type of error happen before, would they make a checklist?
Can you repeat the question? Sorry.
Sure. If on every other occasion a person had not committed an error of this level, would they create a checklist, or would they be overconfident that they're going to remember everything every time?
Yeah, so like most people, we change our behavior because there's consequences to that behavior. So when I forget to do something that's significant, I may try to undo things in the future to make sure that that same thing doesn't happen again. But if it hasn't happened to me, I'm going to be less diligent about it because I haven't had that error happen to me. And I would say that's true with anything. When I have a student miss an exam because they're late, they don't miss the next exam from being late because it hurts their grade really bad.
The state asked you the hypothetical about picking up milk 15 minutes down the road versus picking up milk 5 hours from now when you make it to Miami.
Yes,
I think your answer was that if all things are the same, nothing else is going on, you're going to be more likely to remember it the shorter driving distance, correct?
so I changed that a little bit. I would say if everything was ideal.
Ideal.
So if there were no distractions, if she had the resource, if the person had the resources, if there was good retrieval cues, all the opposite. So all the factors that increase prospective memory errors, if you kind of take the flip side of it, it's going to make it less likely to happen, right? So if everything's ideal, you hold all that constant in a good direction, then yes, longer retention interval means more errors. Shorter retention interval means it's less likely to happen. Doesn't mean that it can't happen. It just reduces the chances of it happening. But then you add other factors in there, and that could, how do I say this? It could negate the factor of retention interval. So for instance, if you make the person very, very, very distracted, it doesn't matter how long the retention interval is, they'll make an error right away. I can tell you to do something in 1 minute and distract you really badly, and you're a lot likelier to make that error just as much as if I did it in 20 minutes or an hour. So if I hold everything constant and it's ideal, then sure, you can make that argument.
And you would agree that driving is a divided attention task.
Absolutely.
If you're thinking about other things as you're driving and figuring out breakfast and trying to be on time, would those also be divided attention tasks?
Absolutely.
You mentioned and discussed divided attention. It sounded like as throughout the day of Rhonda Jewell's day. Is that accurate?
From my understanding of her day and Miss Pascal's deposition of how she was attentive with her children and how she babysat them and those kind of things, then yes, she was engaging in multitasking throughout the day, taking care of the children.
So would it be safe to say that she was multitasking and divided attention before she arrived at Stacy's house as well as after?
Yes, I would say before she got there, on her way there, and then after she got there, I would say she was engaging in multitasking in both of those situations.
You testified that you can't get inside the mind of Rhonda Jewell and say definitively that a prospective memory error occurred, that she forgot about Araya in the car. But was there any evidence that you saw that made you think that she had not forgotten Araya in the car?
Objection.
No.
Objection, Your Honor.
Sustained.
I have nothing further. Thank you, Your Honor.
Any other questions of this witness?
Very brief, Your Honor.
Okay, make it brief.
Dr. Cahill, I believe you just told defense counsel that people change their behavior because there are consequences to that behavior. Is that correct?
Generally speaking, yep, it's called operant conditioning, yes.
And you'd agree with me that paying attention to what is most important can affect what you remember?
More attention paid to something, generally speaking, again, everything else held constant, you can't, you can encode things in memory. If you don't pay attention to them, it gets complicated, but generally speaking, you pay attention to something, that's how you can store something into explicit memory where you can actually retrieve it. Okay, did I answer your question?
It does.
Okay.
So it's the person's choice, what they're focused on, yes?
No, I wouldn't say it's a person's choice. No, there's things in the environment that can draw your attention that you're trying to focus here, but you get distracted and you can't pull it. I can get complicated here, but there's selective attention, there's divided attention. So you can try to focus on one thing, but you can get distracted even though you're trying to focus really hard here. You can get pulled away. There's factors that can pull you away. So I wouldn't say it's a person's decision whether or not to pay attention to this or not. They can try to pay attention to this and they can try to give it as much of their attention, but that doesn't mean that they can't get distracted, and it's not, I'm choosing to get distracted. It just can happen.
But you would agree with me that people control what they are focused on.
People control what they're focused on to the extent that there's nothing else in the environment that distracts them. I can say right now I'm trying to focus on your questions as much as possible, but I just heard a thing outside, a lawnmower or something, and that distracts me. I can't stop that from happening. It's impossible.
But if the welfare of a child depended on your attention, you could try your best.
I can try my best, and yes, I can try my best.
No other questions.
Any other questions?
One last question, Judge.
One.
If the baby were quiet in the back seat and not making noise, would that also be a lack of retrieval cue?
Yes, it would.
Thank you.
Any other questions of this witness?
No other questions, Your Honor, and
Yeah.
the witness is excused.
Okay.
Thank you. Thank you,
Doctor,
Dr.
you are excused.
Thank you, the court.
Thank you, sir. Would the defense call its next witness?
Your Honor, may we approach?
You may. Outside your presence. So we're going to send you back to the jury room. We'll make it as quickly as we can. I'm not promising anything anymore, but as quickly as we can. And again, the main rule you need to remember, do not discuss this case amongst yourselves. Don't do any research. Just don't do anything you want to other than dealing with this case. So Mr. Bailiff, if you'll escort the jury back to the jury room, please.
All right.
Do my best.
Seated, please.
Need some coffee.
Mr. Nelson, I believe we have a proffer for, okay, would you please get Mr. Diamond or Dr. Diamond and let's proceed.
I'll grab him.
Okay. We'll be in informal recess for a few minutes till we can find the doctor.
Yeah, yeah, whatever you want. You don't have to any of that.
And then I'll ask you to state your name and then spell your name for the court report.
David Diamond, David, Diamond.
Thank you, sir. Counsel?
Dr. Diamond, are you a neuroscientist and professor at the University of South Florida?
That's correct.
How long have you been a neuroscientist?
I've been a neuroscientist now for about 40 years.
How long have you taught at the University of South Florida?
I've taught at USF for about 25 years.
In earlier testimony, you CV, is that correct?
That's correct.
And that CV is still accurate, correct?
Correct.
What would you define your field of study as?
Globally as the area of cognitive neuroscience.
And how would you describe that in layman's terms?
That's the understanding of how the brain processes information.
Have you ever done any research in the field of memory, prospective memory, or prospective memory failures?
So I've been studying memory all of my career. And in the past 20 years, I've focused on the brain and prospective memory.
Is prospective memory and prospective memory failures, are those widely studied in the scientific community?
Yes, that's correct.
How long have they been studied approximately?
Oh, quite a few, multiple decades.
So you study the brain and how the brain processes memory, is that correct?
That's correct.
Can you tell me what parts of the brain are involved in memory, prospective memory, and prospective memory failures?
So there are two primary areas of the brain involved in prospective memory. The first is we make a plan to do something in the future. So prospective memory is to remember to do something in the future. So you make that plan using your frontal cortex. You use your hippocampus, which is our primary memory structure, to form that memory of what you plan in the future, and then to actually have that memory occur, to reactivate. And so you need for your hippocampus to be active at just the right time for when you're planning to do whatever it is in the future.
Is there any other brain structure involved in prospective memory or their failures?
Well, we have another brain structure called the basal ganglia. And the basal ganglia can interact with hippocampus and frontal cortex and can compete with the hippocampus frontal cortex. The basal ganglia has us do something automatically. And so if we're always, for example, driving from home to work, it's our basal ganglia that allows us to do that almost without thinking about it.
Is that also something associated with habit memory?
Right. So the basal ganglia underlies habit memory, what we call muscle memory, being able to do something automatically without thinking about it.
Do these brain structures normally interact with each other on a daily basis?
Well, these brain structures can be quite compatible, allowing us to do things automatically, the basal ganglia, allowing us to remember information, hippocampus, and plan for the future. But when we're talking about prospective memory, we've got the frontal cortex and hippocampus have a plan. But the basal ganglia can override that plan, and it can have us do something out of habit, which then causes a prospective memory failure.
Are prospective memory failures common?
It's one of the most common forms of memory failures. It's prospective memory.
And you indicated you've spent at least 20 years researching this area, correct?
That's correct.
Would you be able to provide testimony to a jury about how the brain functions, how prospective memory works, and how the failures thereof occur?
Yes, I would be able to talk about the different brain structures, how they interact, how they enable prospective memory to occur successfully, but also how it can fail.
You've testified before in cases involving memory, prospective memory, and those failures, correct?
That's correct.
You've also consulted before in cases involving those things as well.
That's correct.
You've consulted for both the defense and the prosecution in different cases, correct?
I've advised both defense and the prosecution.
You prepared a PowerPoint presentation in this case, is that correct?
Yes.
Would that PowerPoint presentation assist you in explaining your testimony to a trier of fact?
I think it would provide a constructive visual aid.
Dr. Diamond, do you know how many other people are studying the area of prospective memory and those failures?
Oh, this is a very widely studied area. There must be hundreds, maybe thousands of other scientists studying prospective memory.
As far as the research that has gone into prospective memory and those failures, are there numerous articles written by experts in your field about that
Oh,
issue?
certainly articles have been written over decades about this phenomenon.
In this case, you would be testifying about prospective memory failure as it relates to a child who died in a hot car. Is that correct?
That's correct.
Is the field of prospective memory failures as it relates to children in hot cars, is that a specific field or just applying prospective memory analysis in the field of study to factual situations involving children dying in hot cars?
So prospective memory covers a broad range of different kinds of memory failures. Children being forgotten in cars is one category of prospective memory.
Have you published on prospective memory and its failures, generally speaking, over the years?
Yes, I have an online article which has over 100,000 views, specifically about the brain and prospective memory failures. And I published in a peer-reviewed medical journal on the neurobiology and neuropsychology of prospective memory failures.
Have you published anything about prospective memory failures in relationship to hot car child deaths?
Yes, specifically, my peer-reviewed medical journal paper addressed children dying in hot cars.
I think last time you testified at the hearing, I think you introduced that document. Is that correct?
Correct,
And that's been peer reviewed, correct?
correct.
Has your work in the area of prospective memory failures and those failures that relates to hot car child deaths been, excuse me, cited in other experts' work?
Yes, I've seen that. It's been viewed hundreds of times. It's specifically been cited in quite a few journals addressing both the issue of children forgotten in cars as well as the science of children forgotten in cars.
These journals, if you broadly describe, are journals in the field of memory, prospective memory.
Yes, these are journals in the field of psychology as well as neuroscience. I wonder if I might get some water.
Turn that. Dr. Diamond, I'm going to ask you to turn around and look at a slide from your PowerPoint. Ready? Give you a minute. Can you see the top of it, or there you go.
Just, may I clarify? I received a couple of different PowerPoints. The last one I said corrected, so can you just confirm what PowerPoint it is? And I just want to make sure I have the same copy.
I sent Mr. Caldo the corrected one this morning. You should have it.
The last one.
The last one. Yes. Dr. Diamond, can you tell me what that slide is from your PowerPoint?
So this is a publication, as you can see how long prospective memory has been studied, from over 20 years ago, in which these scientists are interested in how rapidly prospective memory can fail. And so these subjects are brought into a laboratory under controlled conditions, and they're given a task, which is to do something such as mental arithmetic. And then they're shown a cue. When they see that cue, they have to remember it. And at the end of performing their task, which is only 40 seconds later, they just need to hit a key on the keyboard. So the idea in prospective memory is you have to do something in the future. You have to remember to do something in the future. And under the control condition, which is the open bar, these people remember it 90% of the time. That's what that 0.9 is. Now, what they've also done with these people is on a subset of trials, they've added a distraction. Briefly, they need to do something else during that 40-second period. And then they ask, do you remember, after seeing that red mark, do they remember to hit the key on the keyboard? And that's the lower bar. That's the one with the diagonal lines. It shows significantly reduced incidence in which people remembered to hit the key on the keyboard. And the really important point about this paper is that it shows a very brief distraction causes people to have a PM failure, prospective memory failure, that is now down to only 60% accurate.
Is this an example of testing that's done on prospective memory and failures of prospective memory, correct?
That's correct. This is just one of many papers that have tested prospective memory and its failure. The emphasis here is how rapidly people forget what was in their plan.
This is one example of the testing that's been done regarding prospective memory and its failures, correct?
That's correct.
Just a moment. Judge, at this point, I've asked the court to reconsider its decision not to allow Dr. Diamond to testify in this case. We'd ask the court to.
Well, does the state first wish to make any inquiry of the doctor?
There's also a few inquiries.
You want to get? Oh,
I can ask it. On your PowerPoint slide, if we can go to the first page. The title there, can you just read the title of your PowerPoint presentation?
Neuropsychological perspective of how it is possible to forget a child in a car in relation to state of Florida versus Rhonda Jewell.
Is it safe to say that the title of your presentation is the bulk of some substance of what you're testifying to? Is that fair to say?
That's correct.
Okay. If we can go And it would be your intention to testify to the items that are in your slide and present them to the jury?
Well, as a scientist, I like to summarize my work. My intention would only be what would be permitted in the court.
Fair. You got to read the last paragraph in the last page?
Like other loving and attentive parents and caretakers, Rhonda Jewell unintentionally and unknowingly lost awareness of Araya in her car.
It is fair to say that that would be potentially within the scope of your testimony today at trial. Is that fair to say?
That's correct.
In preparation for today, are you at all familiar with Dr. Cahill's testimony in this case?
I was not here while he gave testimony.
Did you get a copy of his prior deposition?
Yes, I did.
And are you familiar with that deposition?
Yes, I am.
Okay. And same thing with this hearing. Are you familiar with what he testified to in general at his hearing?
I received one document, which may very well have been his hearing.
Which may have been a transcript from the hearing?
Yes.
Okay. Are you familiar that he testified? Okay, I thought Your Honor said something plausible. To me means that I cannot say with any confidence whether or not leaving Araya Page in the car was because of prospective memory error. Are you aware that that's his testimony?
Yes.
Okay, and do you agree with that testimony?
Well, as a scientist, one has to be open to any possibility, no matter how unlikely.
So if I asked you to whether or not you disagree with that statement, what would your response be?
Based on my interview with Rhonda Jewell and what I read about her from other depositions, I would disagree with him that she committed this act intentionally.
Judge.
We renew our request, Judge.
I've heard your argument. Any argument?
Just we rely on all of our prior motions, arguments, everything else we raised, and now it's.
Okay, well, with due respect to Dr. Diamond, I'm going to continue to exclude his testimony for the reasons that were set forth in the written order that was entered sometime back in September, and for the further reason that the court has allowed the testimony of Dr. Cahill, who also is an expert in the field of prospective memory. So,
Judge, I'd just like a few more minutes with some more testimony, just for the record.
what I don't see any need for it, but if you want to do it, yeah.
Yes, sir. Thank you. Dr. Diamond, in this particular case, you had a chance to look at the facts of this case. Is that correct?
That's correct.
Now, in general, can prospective memory have catastrophic effects?
Yes, it can.
Have there been studies of airlines and other things that would indicate that?
That's correct. Planes crash as a result of prospective memory failures.
Do you, in your field of study, use surveys to help analyze prospective memory and failures of prospective memory?
Yes, I do.
What is a survey, generally speaking?
So in a survey, you're looking for a representative group of people. You can ask them questions that can provide some insight to understand a phenomenon.
Approach the witness, Judge.
Any questions? Can Dr. Diamond be excused? Oh, okay. I'm sorry. I thought you were through.
Dr. Diamond, I'm going to show you a document. Tell me if you recognize what that is.
Yes, I recognize this. This is a survey of over 1,000 parents with young children. These are also caregivers, yes. That's right, parents and caregivers, all of whom transport children 6 and under.
Can you generally give an overview of what
As far as to me, the most important feature of this survey is that they found that almost all, 88% of these people said that they can't imagine that they would never leave and forget a child in a car.
Is that something that experts like yourself rely upon in having opinions about this?
Yes, I find that information very useful.
And surveys are a common way to gather information.
That's correct.
I'd like to move this into difference number 2.
Any objection?
No, sir.
Then it will be received as Defense Exhibit 2 for the proffer purpose.
Judge, just want to be 1,000% sure that doesn't end up back in the jury.
Right, by all means.
Doctor, can you give us an example of how a habitual memory action can override conscious intentions?
Well, we have these kind of experiences on a regular basis. You have the intention of, well, first you have a normal drive home from work. And on a particular drive, you have a plan to stop at the pharmacy to pick up some important medication. So that's now a prospective memory. On your drive, you follow the route that you have gone hundreds, maybe thousands of times, and you drive right past the pharmacy, you end up at home. The failure to remember the plan to stop at the pharmacy is a failure of prospective memory. That is when your habit memory overrides your prospective memory. That is when your basal ganglia, the brain structure that controls habit memory, overrides the hippocampus, which has the responsibility to remind you to stop at the pharmacy.
In the PowerPoint presentation that you would have used had you testified in this case, you have slides, explanations of these kinds of things, correct?
Correct.
There are also some studies in your slides regarding the number of children left in cars, correct?
That's correct.
And that's done by the Pediatric Association.
Well, it's done through a few different organizations, kidsincars.org, noheatstroke.org, as well as newer organizations that maintain a database of the number of children that die in hot cars.
Again, these are things that you use in your field of study, correct?
That's correct.
One particular study from 2024 from the Traffic Injury Prevention Coalition, they talk about what they refer to as PVH, which is pediatric vehicular heat stroke. That's the same thing as a child dying in a hot car, correct?
Correct.
Do you recall what they found in that study?
Well, what they found is that approximately an average of about 30 to 40 children per year die of heat stroke as a result of being forgotten in cars over the past 25 years.
Do they discuss in this article how that occurs?
Well, they use my research to discuss how that occurs, specifically citing my research with an entire paragraph covering my research.
This is the research that you documented in your article that was introduced several months ago in a hearing, correct?
Right. They cited my peer-reviewed publication with an extensive discussion of my findings to explain how it is that prospective memory fails, specifically with children forgotten in cars.
First slide. Dr. Diamond, in this case, you came to a conclusion about what you believe happened in this case. Is that correct?
That's correct.
What information did you have prior to making that conclusion?
I interviewed Mrs. Jewell. I watched the video of her when she was being questioned. I also read depositions. I read the police report. to come to my conclusion.
So what's your understanding of what occurred in this case that would have caused a prospective memory failure for Mrs. Rhonda Jewell?
So Mrs. Jewell had a habit, her routine for several months was to go straight to Stacy Paschal's house. From her house to Stacy Paschal's house. Take care of her children. That routine changed.
I'm going to ask you to look behind you here. We're going to pull up a slide here from your PowerPoint. The slide that's currently on the screen, could you tell us what that is?
So this is a visual that I use to help to understand someone's habitual performance, their habit memory. So what you have here is the route that Miss Jewell took from her home to Stacy Paschal's home, which she followed for several months. So this became part of her habit memory.
And that's the basal ganglia, correct?
And this is ultimately controlled by the basal ganglia, which allows you again to go on a route without thinking about it. And it's this motor memory that we talk about.
And the next slide we're going to show you, can you tell us what that is?
So things changed. When in June, she picked up Araya on the way to Stacy Paschal's home, which ended up actually on the same street, 6th Street. So she's now changed her route for a relatively short period of time, for a few weeks. So she now has a new route to follow, which overlaps with the old route.
And the next slide that we have.
So things now changed on the week of July 12th. And now it's become different almost every day. So on July 12th, Ms. Jewell did not go to Stacy Paschal's house. She picked up Araya and then returned to her home where she watched Araya. So she's now got a different route.
The next slide that we have.
Now we're back to the routine route. That's July 13th. She's once again back to the route that she followed for months because Araya was not available to her that day. So on that day, she did not take care of Araya. She went straight to Stacy Paschal's house, reactivating that old habitual memory.
And the next slide that we have, Doctor.
Things have now changed again. On the following Monday, she has now picked up Araya and has not gone to Stacy Paschal's house. She's gone to a friend's house where she has now watched Araya for the day.
And the next slide that we have.
So on Wednesday, July 19th, we're now back to Mrs. Jewell picking up Araya with the plan then to bring her to Stacy Paschal's house. During that drive, there was a good bit going on. It was a rather stressful morning. She had planned on going to Burger King. She was in a bit of a hurry. And as she then left the Burger King, as she reported to me, she lost awareness of Araya in the car. So she then gets back on 6th Street and goes to Stacy Paschal's house.
In the next slide that you have,
This illustrates that in the process, now as she's driving on 6th Street, coming to Stacy Paschal's house, that component of the slide that included Araya has faded. It has now faded from her memory. She arrived at Stacy Paschal's house, no longer being aware of Araya in the car. And so when she exited the car, she had lost awareness of Araya.
you use your phrase here, unknowingly and unintentionally on the slide behind you. What do you mean by that?
So we distinguish intentional acts from unintentional acts without knowledge. So at the moment, we can query what is going on with Rhonda Jewell. Is she aware of Araya in the car? The answer is no. Is she intending to leave her in the car? The answer is no. So it is an unknowing and unintentional act to leave this child in the car.
When you say lost awareness, are you saying that she forgot that Araya was in the car?
Yes, she did forget that Araya was in the car. The addition of talking about awareness helps to explain why she forgot.
And so the events that you described just in the last few moments, are those things that have occurred in your research to other individuals, this loss of awareness?
Yes, I personally have handled dozens of cases in which children have died in hot cars. And there is such a consistent pattern in which the parent or caretaker has had a routine drive that does not include the child. And so at the time in which they have gone to their destination, to them, this is a drive that does not include the child. They have lost awareness of the child. This is what every parent, and I'm talking about dozens of parents and caretakers, have reported to me. They thought they were on a routine drive. And as far as the child, they had lost awareness of the child. So when they exited the car, they were not aware the child was in the car.
A couple last things really quick. I haven't shown you the entire slide, PowerPoint, excuse me, but you've reviewed that, correct?
The entire PowerPoint?
Yes.
Yes.
I mean, you produced it.
Yes.
I've shown you some. Are those accurate from your PowerPoint presentation?
Yes.
And the flash drive that you gave me that contained that would contain the entire PowerPoint presentation you wanted to present if you testify in this case. Is that correct?
That's correct.
Because we're going to ask the court to let me move into evidence for purposes of proper PowerPoint presentation.
Any objection?
Again, same, just, yeah, as long as they're not going back.
I will go ahead and receive it as Defendant's Exhibit 3 for proffer purposes only.
The last thing, Dr. Diamond, if you were to testify in this case, would you testify that in your expert opinion, that Rhonda Jewell lost awareness or forgot that Araya was in the car by the time she arrived at Stacy Paschal's home?
Yes, I would testify to that.
I have no other questions, Your Honor.
The state has indicated it has no questions of Dr. Diamond. Can he be excused at this point?
Yes, sir. We're going to ask the court to reconsider and have him testify.
Same ruling.
Thank you.
Okay, Dr. Diamond, you are excused. Thank you, sir. Got everything? Okay, it is about 5 minutes to 12 or so. Time for the lunch break. Is the defense going to announce rest at this point? We'll have you announce it again when the jury comes in.
We will announce rest at this time, Your Honor.
Very well. What we'll need to do, I assume you will want to renew your motion
Yes, sir.
before we bring the jury in, but we'll take our lunch break, come back, hear your motion, and then bring the jury back in, I suppose. Okay. We are in recess, but I would like to speak to council. We'll be back at 1:00. for lunch. The defense had announced rest. What we'll do, we'll bring the jury back in and allow you to announce that in their presence. And we'll go from there. First, does the defense have a motion?
Yes, sir. So we would move for a judgment of acquittal again. Your Honor, we would renew that motion. No reasonable jury would be able to find Ms. Jewell guilty of count 1, 2, or 3 after the close of our evidence. First, with culpable negligence, just pointing out the jury instruction language. It says if there's a violation of that duty, referring to a duty of care everyone owes to each other, without any conscious intent to harm, that violation is negligence, it's not culpable negligence. During the state's case and our case, no evidence has been presented that this was a conscious intention to harm Aria. So culpable negligence has not been proven. I know that the state previously cited Taylor v. State and Leap v. State in their last argument against this motion. In Taylor v. State, it's a woman who tested positive for meth in the hospital. She was instructed not to sleep with the baby in the bed with her. She knew that she was a heavy sleeper when she used meth. She used meth the night the decedent passed away. She also chose to sleep in the bed with that child knowing that she was a heavy sleeper. She woke up throughout the night, never checked on the child, and the child was dead. That shows conscious intention right there. Similarly, Leap v. State, similar facts. The defendant was dating a mother of a child. The defendant knew that there was an open DCF case against the mother for beating the child. He repeatedly saw signs of abuse, made the conscious decision to ignore those signs of abuse and not report them. And that's another conscious choice there. The jury instruction indicates consciousness or intention is required. The state has presented no evidence to support that this was a conscious decision with the intention of harming Aria. So for those reasons, count 1 has not been proven, and we would ask for a judgment of acquittal on that. Turning to the felony murder, count 2. I know the state took issue with me referencing the New York felony murder statute. That is part of the analysis of the Florida Supreme Court case I previously mentioned, Studevant. And that case really talks about the difference between enumerated and unenumerated predicates for felony murder. And that case was dealing with an aggravated child abuse, right? But that is enumerated within the statute. And the court determined that because it's enumerated, and it was just one single act, but because it was enumerated, it doesn't matter that it's wholly subsumed into the felony murder. It can provide a predicate in and of itself, and they can be convicted of both. Comparatively, the court discusses when crimes are unenumerated, and if the harm is directly tied to the crime as an element of the crime, that is not an appropriate predicate there. This crime is unenumerated. It would fall under the last subsection without an intent to do harm. And our position, which is supported by the holding in Studevant by inference, is that this predicate is not an appropriate predicate for felony murder. Additionally, there are concerns the court needs to be aware of with this predicate, as the court has determined that there is no mens rea associated with this crime. When the Supreme Court evaluated the constitutional nature of the felony murder statute, they decided that because the intention from the predicate felony transfers to the felony murder, then that satisfies the jurisprudence surrounding there needing to be an intent for murder. And there is no intent or mens rea at all based on this court's ruling. So there is no mens rea to transfer. So for that reason, in addition to the one I previously mentioned, this is not an appropriate predicate for a crime, for felony murder rather. And as such, the court should enter a judgment of acquittal for felony murder. Lastly, we would still assert that knowledge is an essential element of the predicate crime, and there's been no evidence presented that indicated that Ms. Jewell knowingly left the child in the vehicle. So for those reasons, we'd also ask for a judgment of acquittal on that.
State wish to respond?
Very briefly, Your Honor, if I may. Your Honor, the state has put forth evidence that, taken in the light most favorable to the state, as a prima facie showing that a reasonable jury could find the defendant guilty. The state would renew all of its previous arguments made at the first judgment of acquittal. And now there's additional evidence that was put on during the defense's case. So beyond where we were the first time this argument was made, we also had the defendant's own testimony in addition to other evidence. If the legislature had designed or intended to preclude certain felonies, it would have written the statute to that light. So based on the previous arguments, the additional evidence before the court at this juncture, the state would request the denial of the judgment of acquittal.
Morning, John.
Yeah, I would just point out that there has been no evidence that this was a conscious act whatsoever. And the state's argument didn't highlight any of that when we would stand on our other arguments.
Okay, I'm going to deny your motion for judgment of acquittal at this time. I still believe that these are questions for the jury to decide. Are we ready for the jury at this time?
Yes, Your Honor.
Okay, what we're going to do when we bring them in, I'll ask, or the defense can announce it's resting. And then at that point, we will move into a closing argument. Bring them in, please.
All right. All jurors present.
Be seated, please. Would the defense call its next witness?
Your Honor, the defense announced rest at this time.
Very well. Members of the jury, both the state and defendant have rested their cases. This means that you've heard all and received all of the testimony and evidence pertaining to this case. The attorneys will now present their final arguments. Please listen to what the attorneys say, and remember, it is not evidence, but you should listen carefully to their arguments. In making their arguments, the attorneys will be referring to the evidence presented or not presented during the trial. The attorneys will not intentionally misrepresent the evidence. Rather, they'll be relying upon their recollection of what the evidence was. Your recollection of the evidence may differ from that of the attorneys, and in that event, you should rely upon your own recollection of the evidence. These arguments are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has spoken. State ready to proceed?
Yes, Your Honor.
Please do.
May it please the court, counsel. Good afternoon, everyone. I know it's been a long week. I appreciate your attention. The defendant in this case, as you know, has been charged with 3 different offenses, crimes. First one was aggravated manslaughter of a child. Second one was third-degree murder, not premeditated during a felony. And the third one was leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or as in this case, death. I want to go through these counts in a little bit of detail, and there are lesser included offenses as well. So I want to go through that. The state, in order to prove aggravated manslaughter of a child, has to show three things. One, that Araya Page, the victim in this case, the 10-month-old infant, is unfortunately deceased. She is dead. We have proven that. Number two, the death of Araya Page was caused by the culpable negligence of the defendant, who is seated in the courtroom today. I want to tell you, the court's going to tell you later during the jury instructions what is culpable negligence. The judge is going to read to you a bunch of instructions, but I want to tell you just a small portion of it. Culpable negligence means that every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The important thing here is if there's a violation of a duty to be a nanny, a duty to be a babysitter, even if you don't have a conscious intention to harm somebody, then it is culpable negligence. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm to the victim, in this case being Araya Page. And the state has proven that the defendant engaged in a course of conduct by leaving the baby in the car for a little bit over 5 hours. That is, it is reasonable to expect that the baby would die. Another thing I want to say about neglect. Neglect can be based on repeated conduct, meaning it happens many times, or on a single incident like this one, or omission by a caregiver. The defendant admitted on the stand she was a caregiver. Omission by a caregiver that results in or could reasonably be expected to result in serious physical injury, or in this case, death. That's what we have here. This is aggravated manslaughter of a child. The state has proven all three elements, but there are some lesser elements, offenses, I should say, and I'm going to go through these. The state feels that you should find the defendant guilty of aggravated manslaughter of a child, but the first lesser is manslaughter. This is the difference between manslaughter and aggravated manslaughter. Manslaughter, I need to show two things. One of them is Araya is dead. Obviously, we've proven that. Unfortunately, she is deceased. Two, the death of Araya was caused by the culpable negligence of the defendant. Once again, we proved that. That's all I need to prove. The difference, aggravated manslaughter has a third element that we proved, that was a child at that time. She was only 10 months old. Brooke and Justice both took the stand. They told you what her date of birth was. They told you she was 10 months old in July of 2023. Paul Dickinson, the EMS paramedic, took the stand and said he determined she was 10 months old. Dr. Aaron Ward took the stand. He said she was 10 months old. Dr. Thomas Coyne, the medical examiner, said he determined she was 10 months old. The state has proven she's a child. So there's no doubt of that. Also, for this to be aggravated manslaughter of a child, the state has to show a caregiver. That's the key word, a caregiver, that the defendant was a caregiver for Araya, and we have shown that. So the state is saying to find her guilty of aggravated manslaughter of a child. We have met all three elements. The regular manslaughter doesn't really involve a child. Then we go to another lesser included offense that you have a choice of. Once again, the state is not asking you to find her guilty of this one. We want you to find her guilty of aggravated manslaughter of a child. The next one is called neglect of a child with great bodily harm, permanent disability, or permanent disability. This is what I would need to show. Number one, the defendant by culpable negligence failed or omitted to provide Araya with care, supervision, and services necessary to maintain her physical or mental health. Two, that the defendant caused great bodily harm to Araya. Three, she was a caregiver. Four, that Araya was under the age of 18. Well, there's one thing missing here. I don't need to prove that Araya is deceased or that she's dead in this one. That's why the state is saying, no, we want aggravated manslaughter of a child. Araya is dead. That's the proper one to find her guilty of. But there's still 2 or 3 more lesser offenses that you can choose from. Another one is called neglect of a child without great bodily harm. That one, we have to show once again that the defendant by culpable negligence failed or omitted to provide Araya with care and supervision, that the defendant was a caregiver, and that Araya was under the age of 18. This one, once again, says without great bodily harm. No, Araya is dead. We go back to the aggravated manslaughter of a child. That is the proper one to find the defendant guilty of. Then we have 2 more left. Culpable negligence inflicting injury. I would have to prove 2 things here. The defendant inflicted actual personal injury on Araya, and she did through, once again, culpable negligence. In this one, the state would not even have to prove that Araya is a child. Obviously, we prove she's a child. We go back to the aggravated manslaughter of a child. That's what we want you to find her guilty of. And the very last one is just culpable negligence exposing a child to injury. No, Araya wasn't just exposed. Araya died because of this. So in the end, with aggravated manslaughter of a child, and you'll see on the verdict form that there are all these lessers, the state is asking you to find her guilty of the very first one, aggravated manslaughter of a child. Now there's 2 more counts that I want to go through, but I want to go do it a little bit backwards. Rather than doing count 2 and then count 3, I'm going to go to count 3, and I'll explain why in a second. Count 3 is leaving a child unattended or unsupervised in a motor vehicle with great bodily harm, or in this case, death. This is what the state needs to prove. The defendant was a person responsible for Araya. State has proven that. Araya was under the age of 6 years old. Once again, the state proved that she was 10 months old. The defendant left Araya unattended or unsupervised in a motor vehicle for a period of in excess of 15 minutes. Think about this for a minute. All the state needs to show you is she left her in the vehicle for over 15 minutes. This defendant left Araya in the vehicle 20 times more than that. 15 minutes is all I need to prove. She left her for a little over 5 hours. And lastly, what I need to show is that in so doing, Rhonda Jewell, the defendant, caused great bodily harm, permanent disability, or permanent disfigurement to the child, Araya. Obviously, she did, because Araya is deceased because of this. We are asking you to find her guilty, the defendant, of leaving the child unattended or unsupervised in a motor vehicle, which resulted in great bodily harm, as in this case, Araya is deceased. There's only one lesser, and basically what that one says is that the defendant left Araya in a vehicle, that the child was under the age of 6, it was over 15 minutes, but there's no injury. that is not one that you would check off. It would have to be leaving a child unsupervised, resulting in great bodily harm or death. Now I want to go to count 2. Count 2 and 3 are linked in that the crimes charged in count 3, which I just mentioned to you, leaving a child unattended in a motor vehicle, is an element of count 2. Count 2 is the third-degree murder charge. This is what the state needs to prove for count 2, third-degree murder, third-degree felony murder. It's unpremeditated. We're not saying that any of this is premeditated. We're saying this is not premeditated. Number 1, Araya is dead. We've proven that. Number 2, and this is the important part where count 3 comes into it. While engaged in the commission of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury, the defendant caused the death of Araya. You remember the example I gave, I think it was on Monday. I talked about if someone committed a felony, if someone robbed a bank, they had no intention of hurting someone. They wanted to rob the bank, and during the course of that robbery, unfortunately, somebody died. It's felony murder. What we're saying is the defendant in this case committed the felony of leaving a child unattended in a motor vehicle, unsupervised, and during the course of that crime, Araya died. That's what makes this a third-degree felony murder. And I stress to you, we're saying not premeditated. And the last element I need to show is that the defendant was a person who actually killed Araya, and she was. No one left Araya in the vehicle but the defendant. She's the one who did it. It wasn't like someone else came along and put the child in a car without her knowing. She drove to Stacy's house. She got there. She left her in the car. There's one lesser for that. It's once again, it goes back to the manslaughter charge, just simple manslaughter. We are not asking for that in this one. We're asking for third-degree felony murder because in this one, she was engaged in the commission of leaving a child unattended or unsupervised in a vehicle, and it resulted in Araya's death. You've all heard in the past 4 or 5 days what happened in this case. But there's some things I want to stress. The defendant in this case failed in her duty as a babysitter, as a nanny. You saw her take the stand yesterday. She actually admitted. These are things, and it's something that the court had just instructed you on. This is what I'm going through is my memory. Go with your memory. I know some of you have been taking notes. Go with your memory. But this is what I have. She admitted on the stand more than once that she failed in her duty of care. I asked her point blank, wouldn't you agree you failed in your duty of care? And she said yes. She admits it was her responsibility to care for Araya. She admitted on that day, for those 5 hours, she didn't do that. She admits that Araya died under her watch. She admits it was her job to watch Araya. She admits it was her responsibility to care for Araya on that day. She also admitted it was her fault Araya was dead. These are things I asked her. And like I said, go with your memory, but these are things she admitted on the stand. These are also things she admitted she didn't do on July 19th. She didn't feed Araya for those 5 hours. She didn't make baby bottles or baby foods, never changed her diaper, never put baby lotion on her, anything you would do for a baby. She didn't do any of that because Araya was in the car for 5 hours. Keep in mind that the defendant in this case is a paid babysitter or nanny. This is her job. Brooke and Justice entrusted her to take care of Araya for those 2 days, every week, whatever it was. They paid her to do this, and she made the decision and said, yes, I'll do this. She did not do this on this day at all. And don't just take my word on it, take her word. She said it yesterday on the stand. She did not do this for those 5 hours. Now let's talk about things she did remember. She remembered picking up Araya that day. She remembered that Brooke put her in the car. She remembered Brooke putting the baby bag in the car. She remembered going to the Burger King or to the red light in front of the Burger King. She remembered going to Stacy's house. She remembered she got a can of chicken, bag of chips, her cell phone, her drink. She remembered that she texted Brooke twice. She Snapchatted with Nevaeh also. But she doesn't remember Araya. But she remembers everything else, but not Araya. The evidence that you heard and what the state has proven is that the defendant went to Brooke's house, Brooke and Justice's house, a little bit before 8. Her job was to get Araya. That's why she got up that morning, was to watch her and the other kids at Stacy's house. She drives to Brooke's house. Brooke puts Araya in the car with the baby bag, and the defendant then leaves. And Stacy's house is like 10 minutes, 15 minutes down the road. It isn't that far. But when she was asked yesterday on the stand by me, did you forget Araya when you were at the Burger King or the light in front of the Burger King? Her response was yes. We're talking about 5-6 minutes. You get up in the morning, you drive to someone's house to pick up their child, and in 4 or 5 minutes, you forgot all that? You forgot you got a baby in the back of the car? That doesn't make sense. Then she gets to Stacy's house, she gets out of the vehicle, Araya is still in the vehicle, but she goes in with everything else in her hand, the cell phone, the chips, and the chicken, and all that. But Araya is still in there, in the car. What was also interesting was when she's inside of the house at 8:17, and you can take this into evidence, the text message, you've all seen it. At 8:17, she texts Brooke to let her know that Stacy has left. And I asked her yesterday when she was on the stand, didn't that ring a bell? You're talking to Araya's mom. And she said, no, we talk all the time. And I even said to her something to the effect of, but you're texting her at 8:17 in the morning to let her know Stacy has left. Why else would you be doing that? Unless you had Araya with you. Then you text her another communication at 8:32 in the morning. Still, nothing went off in her head. Araya's in the car. She says, I forgot. It doesn't make sense. Then at 11:25, she talks to Nevaeh Carter. That's Araya's aunt, the young girl that took the stand yesterday. And she's that Snapchat photo responding to it. The point is she's having communication with her. Nothing goes off. But this is something else that's strange. When Brooke comes to pick up Araya, she knocks on the door, and we know this, there's no answer. She rings the doorbell, there's no answer. She then calls the defendant. And think of it. At that moment, when she calls the defendant, and the defendant says to her, what door are you at? And she says, the front door. She's talking to Araya's mom. She's talking to her on the phone, hears her voice. It still doesn't go off that Araya's in the car. This doesn't make sense. And it is only when the door is opened and Brooke walks in, at that moment, the defendant starts screaming, Brooke, Brooke, and runs out. So it didn't go off at 8:17 when she sent a text, 8:32 when she had another text, 11:25 when she talks to Brooke on the phone at around 1 o'clock or 1:15. None of that. It doesn't make sense. We all know what happened after that, unfortunately. EMS is called, Brooke calls 911. They arrive, the sheriff's office arrives, the fire chief arrives. Paul Dickinson took the stand and he told you they were desperately trying to do CPR. Brooke had called her mother-in-law, Pamela Page, because she's a nurse for over 30 years, desperate to try to do something to save Araya. She said that I think the word she used was she felt, I think she said wet and rubbery. Her lips were blue. She's trying to desperately do CPR. Her mother-in-law is telling her, this is what you need to do. Paul Dickinson comes in with his paramedic with him, and they both take over trying to do something. But he even said on the stand, he realized that Araya was dead already. They noticed that the muscles had stiffened, rigor mortis had set in. The child was already deceased. And they then transferred the child to the hospital. Dr. Aaron Ward took the stand. He confirmed, obviously, that Araya unfortunately was deceased. After he got off the stand, the nurse took the stand, Charles Smith. And Charles Smith said that the temperature was taken of the child. And at that point, and keep in mind, Araya has been taken out of the car, put in a garage so they can try to do CPR, put in an ambulance, which I assume was probably air conditioned, but put in an ambulance, taken to the emergency room. And I'm sure the emergency room is air conditioned. So some time has passed, but her temperature at that point is 110 degrees. And Nurse Smith said he doesn't remember if the thermometer went over 110. Maybe it did, maybe it didn't, but it was 110 at that point, meaning it could have been higher. And then Dr. Thomas Coyne, the medical examiner, took the stand. And really, what we learned from that was he said the cause of death was hyperthermia, overheat of the body. But he also said that when he did the internal exam and the external exam of Araya, she appeared to him to be a perfectly normal child. He could find nothing except that she had been left in a car for 5 hours. He described what happens when someone is in that situation or an infant is in that situation. He described what happens to a person or infant's body, their organs, their brain swells, what someone would be going through in that situation. The defendant, as you know, was interviewed by investigator Brad Dougherty. I'd like to show you a clip of that if we could.
We'll come in and talk to you, okay? Sir, you wait out home. Yes, no problem, sir. You can have a seat out here in the hall next time. I'm taking care of this and take the courage. I know this is very difficult. Okay? You just gotta get through it, get a statement from you. But because you are here at the sheriff's office and we're here talking to you in here, I gotta still let you know what your rights are, okay? Doesn't mean that you're arrested, just means you gotta know what your rights are because we're talking to you in a place you may not feel free to leave, okay? So to take the courage and I'll read those to you.
All right, Mr. Rhonda, you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer and have him or her present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements Do you understand these rights as I've explained them to you? Okay, with these rights in mind, are you willing to answer some questions for us?
I know this is tough. I know it's very tough. Just kind of walk me through the day and what happened.
I picked her up about 8 o'clock. I usually keep her 2 days a week. So I work Monday at my other job, but some things that fell through her husband only won't work night shift, so I went back. I went this Wednesday and Thursday at this place where I was at today.
The house where you was at today?
Which they have twins and a girl that I keep. Anyway, so on the same days, I pick up Araya from her house. But today was an earlier day because the other lady needed me at 8:15, so I picked her up at 8 o'clock, which is usually 8:30. Anyway, so I picked her up and I pulled through Burger King to get something to eat, but the line was too long, so I left and went to the job I was at.
On the State Street, correct? Right.
So I got there at 8:15, and the baby was like, because she was asleep, and she was quiet. And because I don't keep her every day, I forgot she was there. So I went inside, got busy with the other kids, and I even talked to the mom throughout the day, and it just didn't click.
Right.
That the baby was outside.
So that was at 8 o'clock. What time did you realize the baby was outside?
When I was girl,
You know what time roughly that was? When 911 was called? Okay. How many kids were in the car when you got home with her, when you got to that house today? Just her?
Just her.
Just her? And the other kids were there, I'm assuming you babysit them for the family that lives at that house? Is that what they were already there? The homeowner that lives there, what's her name? You know?
Stacy.
Stacy. Did Stacy know that you was bringing the other child?
No, because sometimes I have her and sometimes I don't.
Okay, so she had no idea. And where did you park at the driveway?
In the rocks.
In the rocks?
Pulled off into the rocks.
And the only reason I'm asking, I didn't know if maybe they would have seen anything when they left, when they left there. The stuff that's in the car, the baby stuff, is that for that child?
Yes, sir.
Okay. How long have you babysitted this child? How many?
Since probably June.
Since June of this year? Does he do it every week or every day, or how does that work?
I was keeping her Mondays, with my other job, Monday, Wednesdays, and Thursdays. But she come to me a couple of weeks ago, about a month ago, and said, hey, my mother-in-law's gonna keep her on Thursdays, so we'll just have her Mondays and Wednesdays.
Okay.
And so because I didn't have this other job on Mondays because of their work schedule, I was off I kept her on Mondays, so I went and got her on Monday, and I done all my errands in McClenny. And
Sorry.
I keep her till 1, till her mom comes and gets her. So I done all my errands in McClenny, and her mom come and got her at 1 o'clock. That was on Monday. And on Tuesdays I have off. And on Wednesday I went to my other job, and I usually take her with me. But that was on Wednesdays. On Thursdays I didn't have her anymore. On Thursdays her mother-in-law kept her.
So you said, just to go back and reiterate, you said when you got there to the house on the State Street that she was sound asleep. Was the plan to come out and get her a little bit, or?
No, I normally just get out and get her and take her inside.
But I'm saying, you said you noticed that she was asleep when you got there.
Well, I assumed she was asleep. She wasn't making any noise.
Okay, she wasn't making any noise.
Yeah, I just picked her up. Her mom said that she would probably go to sleep, so I just assumed she had fell asleep, but she didn't make any noise.
This is what's interesting, and Investigator Dougherty questioned her on it further. And you can listen to that again if you need to. When you're in the jury room, you can come out, we can play it for you again and again. But she mentions to Investigator Dougherty that she got there, I think she says at 8:15, and she says something, the baby was, and then it's inaudible, I can't hear what she's saying, hard to make out, but she says the baby was something because she was asleep. She was quiet, and because I don't keep her every day. And then she says, I forgot she was there. And I go inside, I get busy with the other kids. Then she says, I even talked to the mom for a bit. It didn't click that the baby was outside. The investigator, Dougherty, then says to her later, like 3 minutes later, he says, you said you noticed she was asleep? And her response is, I assumed she was asleep. She wasn't making any noise. The mom told me she would probably go to sleep, and she wasn't making any noise. It's like two different stories. There's an inconsistency there. According to the defendant, if you believe what she said yesterday, she forgot Araya was in the vehicle by the time she got to the light where Burger King is. But my memory is when she was then questioned after I questioned her by defense counsel, it was, I don't remember if it was there or when I got to Stacy's. So in a matter of a minute or two, the story somewhat changed again yesterday when she was on the stand. You've seen this video. Keep in mind that this video, this interview of this defendant was done, I believe, at 2, you can look at the time, I think it's at 2:42 on July 19th or 2:41. Brooke has testified that she got to the house about 1:15. So it's roughly, I'll say about an hour and a half later, she's being interviewed. About an hour and a half after realizing Araya is now dead. You can judge her demeanor on that video, how she appears to you. And I ask you to take that into account. You can judge her demeanor yesterday on the stand, how she appeared to you. And I ask you to take that into account. The body cam footage that we saw yesterday. You can watch that if you want to watch it. You can ask the court. You'd have to come out here. We would play it for you as well. This defendant cared for many things that day. Her phone, her trip to England, her kid is going to college, her lunch, her cell phone, but she didn't care for Araya on that day. She didn't watch Araya and make sure Araya was safe. She failed in that duty. Today, we heard from Dr. Brian Cahill. That was the expert that the defense put on the stand. I have a few things I want to say about Dr. Cahill. He talked about this thing called prospective memory error, forgetting to do something. In this case, it would be forgetting that Araya is in the car. When the court reads to you the jury instructions, you will never see the words prospective memory error. It's not in there. You will never see the words, I forgot. It is not in there. It's not part of the jury instructions. A reasonable person might forget to lock the door when they leave the house. They might go back and check on it and realize, okay, I didn't lock the door. That isn't what we're talking about here. We're talking about a babysitter that left a 10-month-old in a car for over 5 hours. That's what we're talking about here. Dr. Cahill mentioned something. He said 25 is a number he threw out. And parents forget their kids are in the car. That was the number he threw out. He didn't mention, at least from what I heard, unless you heard something different, do these parents, did they forget their child was in a car for a minute and then remember the child was in a car? Did they forget their child was in a car while they were listening to a song and 3 minutes later they realized the child's in the car? Did they forget their child was in the car for 2 hours, for 3 hours, for 5 hours? He didn't say. Is it just a moment? Is it hours? He didn't elaborate on that. But in this case, once again, we're talking about a babysitter who's being paid. She took the responsibility to care for this child, and she failed, and she admitted that on the stand. Dr. Cahill also talked about being rushed in a routine, that it can affect your memory. This isn't an excuse. Every person has some sort of a routine, and every person probably every day, something comes up you're not expecting and you're rushed to do it. That doesn't excuse this kind of behavior. He mentioned something called retrieval cue. Something, I guess, to remind you. However, he said the text messages aren't a retrieval cue because they don't mention Araya in there, even though she's having contact with Brooke, the mother. The Snapchat, he said, isn't a retrieval cue because Araya is not mentioned in it. But a phone call from Brooke at 1 o'clock, the actual mother calls her, that's not going to be a retrieval cue? I don't know what would be if that isn't going to be one. To the state, the other ones are too. This isn't anyone's fault, but the defendant's fault. It isn't Stacy Pascal's fault. The baby it seems, was asleep. Obviously, it's not the baby's fault. The baby's sleeping. She had the responsibility to care for this child. She failed in her duty. Just because you forget to do something doesn't mean that you can't and shouldn't be held responsible for it, that you shouldn't be accountable for it. I've given you this example on Monday. And I said, what if you have someone who is driving on the roads? They have a duty of care to be careful for themselves, but also for people who are driving around them. That's their duty when you get behind a wheel. If they're texting and they cause an accident and somebody dies, there's no intent that they wanted that to happen. They can't just say, I'm sorry, I didn't mean for this to happen. They're going to be held responsible and accountable. Something horrific happened. Like in this case, she says, I forgot. She has to be held accountable. She has to be held responsible. Araya is dead. Araya is dead forever. She's not coming back because she didn't do her duties that she said she would do. Another thing I mentioned on Monday, I mentioned about, I always call it the school bus puzzle. If some of the pieces of the school bus puzzle weren't in place, would you be able to say it's a school bus? Everyone, I think, said yes, they would, if it was missing a few pieces. This puzzle's a bit unique in that the state feels none of the pieces are missing. I could go through all the evidence that I've mentioned so far, but I'm not going to. But it's the text messages, what happened that day, the doctors, the witnesses, all of that. They're all pieces of a puzzle. But the biggest piece of the puzzle is she took the stand. She actually admitted that she failed in her duty, which makes her guilty of all the offenses. I mentioned to you, the judge is going to read you the jury instructions shortly. There's just a couple that I want to point out that I think, well, they're all important, but a couple I'd like to mention. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and the instructions that the judge will read to you. This case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Look, when you are part of a trial, it is easy to have your emotions affected. We're all human, that can happen. But you were all entrusted as jurors to follow the law. You can't let your emotions decide your verdict. You must decide this case on what the law says and what the facts are. Not how you feel about someone, whether you like someone or hate someone or feel sorry for someone. That isn't what we're here for. The facts show that she failed in her duties and Araya is dead because of her. That's what the facts are. And if you follow the law, you would find her guilty on all 3 counts. I will talk to you again after the defense does their closing. But I'll just end it for now with this. The state has proven this case beyond a reasonable doubt. We're asking you to find the defendant guilty of aggravated manslaughter of a child, Araya. We're asking you to find the defendant guilty of leaving a child in a vehicle unintended for over 15 minutes because she left her for over 5 hours. And because of finding her guilty of that count, the 3rd count, you have to find her guilty of count 2. Because if someone leaves a child in a vehicle for over 15 minutes and they're dead, count 2, the felony murder, says if you commit a felony and somebody dies, then you're guilty of 3rd-degree felony murder. So the state feels we have proven all 3 counts, and we ask you to find her guilty on all 3 counts. Thank you for your time.
Defense?
Thank you, Ron. May it please the court,
You may proceed.
counsel. Brooke, oh my God, Brooke, I forgot the baby. I forgot the baby. I forgot the baby. How could I be so stupid? How could this happen? Those are all words that you all heard that Rhonda Jewell said on this day. This case comes down to whether Rhonda Jewell consciously did an act that led to the death of Araya Page. On behalf of myself, my co-counsel, Mr. Nelson, Mr. Badger, and our client, Ms. Jewell, and the state as well, we appreciate your time and your attention to this case. And we offer our condolences to the family of Araya Page. This is a tragedy for Araya, a tragedy for her family, and it's a tragedy for all those who knew her, including Rhonda Jewell, who loved her like her own. This is a hard situation that we have put you all in. It is human nature to want to hold someone responsible for the death of a child that was a bubbly, happy, 10-month-old child who seemed perfectly healthy, and her life was cut short. We acknowledge that, and we understand that. And we understand that we're asking you to do a difficult job. But you have to set aside the emotions of the fact that this case involves the death of that beautiful child. Because as the state told you, the judge is going to read you instructions, and you're going to get a copy of those too, so you don't have to write down every single thing that we say. But the judge is going to read you instructions that say, just as Mr. Yazdia said, this case can't be decided for or against anyone because you feel sorry for them or because you're angry at them. And your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Rather, it has to be based on the evidence, on the law that's contained in the instructions. So your job is to decide what facts have been proven. And in doing so, you have to think about what facts that have not been proven. And you have to take those facts and apply them to the law that the judge gives you and hold the state to its burden of proof in this case. The state has to prove each and every element of these three crimes beyond and to the exclusion of a reasonable doubt. And so the state went through these charges with you. And I'm going to do that a little bit quickly. In doing so, I ask you that if I say things that are not the way you remember them, if I reference facts that you think are not the correct way that they were said, please rely on your memory and not mine, because that's your job, is to figure out what was said and to judge the credibility of this case. So as I said, we put you in a difficult spot. We are asking you to deal with the circumstances that led to the death of a child. But ladies and gentlemen of the jury, accidents happen, mistakes are made. The question that has to be answered here is whether the mistake in this case rises to the level of culpable negligence. And the court will define for you what culpable negligence is. And so you have to take those facts, as we said, apply the law, and make a decision. And I submit to you, ladies and gentlemen, that although a tragedy occurred, there was a mistake that occurred, and Araya Page passed away because of that mistake, a crime was not committed. As I said, the state has to prove culpable negligence related to aggravated manslaughter of a child. So let's talk about that standard of culpable negligence. The state indicated when Mr. Yazdia stood up here, he said that every person has a duty to act reasonably towards others. And if there's a violation of that duty without any conscious intention to harm, that violation is negligence. And that's what's in the jury instructions. But that's negligence. Mere negligence is not enough to convict here. It has to be culpable negligence. And so that definition is something that I'm going to walk through with you and explain why we feel, the defense feels, that the state has failed to prove culpable negligence. So it's not just that someone owed a duty. Mr. Yazdia went through and through the fact that Rhonda Jewell was Araya Page's nanny. That is accurate. She had a job. Her job was to care for the child, and that was her duty. But the issue is, did she consciously do something that interfered with that duty? Is there culpable negligence here? So the jury instructions say, again, the defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. Culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. We do not have gross and flagrant negligence here. What we have is an accident. Rhonda Jewell forgot the baby. You don't look at the outcome. You don't look at the fact that Araya is deceased to determine whether negligence is gross and flagrant. You look at what happened. What was the negligent act? Negligent act here was that the baby was forgotten in the car. Forgotten, not consciously done, not culpable negligence. Obviously, the outcome here was a horrible tragedy. And the state keeps talking about the fact that Araya was left in the car for 5.5 hours. It's important to remember that the medical examiner, Dr. Coyne, indicated that it was likely that Araya died within 20 to 30 minutes inside the car. Still horrible, still a tragedy, but it's something important to remember. And it's horrible no matter how long it took to occur. But again, you don't look at the outcome to determine whether the negligent act was gross and flagrant. You look at the act itself. Looking at the conduct itself, the conduct on the part of Rhonda was not a conscious decision, not a conscious act, not something done on purpose. The jury instruction goes on to say that culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want or lack of care as to raise a presumption of a conscious indifference to consequences. Conscious indifference to consequences. You all saw that body cam footage of when the officer arrived and walked into that garage. You saw Brooke Page walk out and how upset she was. And right behind her was Rhonda Jewell, and she was just as upset as Brooke Page. Was that the face of someone exhibiting a conscious indifference to human life, or a conscious reckless disregard of human life? I submit to you that it was not. Jury instructions go on to say, the negligent act or omission, again, must have been committed with an utter disregard for the safety of others. There was no conscious act done here. It was simply, she forgot the baby. Culpable negligence under the jury instruction says that is consciously doing an act or consciously following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. People know that you can't leave people or children in cars, that can reasonably lead to injury. But again, here, there is no conscious act on the part of Rhonda Jewell. She forgot the baby. Rather, what we have here is a tragic accident. There was no conscious choice on the part of Rhonda Jewell to leave Araya in the vehicle. The state seems to suggest that they just want you to ignore that part about culpable negligence and just say, well, there was a duty here. She didn't complete the duty. The baby passed away. That's it. That's all we have to prove. But again, that's not what the law says. And you all promised to follow the law, even if you didn't like it. And I know, again, we put you in a tough situation because human nature is you want to hold someone accountable. But this is not a crime. The state has failed to prove that a crime occurred. The state has failed to prove anything more than Rhonda forgot this baby in the car. There is no evidence that has been presented that indicates anything other than the fact that she forgot. And ladies and gentlemen, accidents happen, and sometimes they have tragic consequences. The state keeps saying, well, she remembered picking Araya up from Brooke. She remembered this, she remembered that. It doesn't make sense. Does it make sense that the text messages didn't trigger her? It doesn't make sense. Does it make sense? Ladies and gentlemen, the only way any of this makes sense is that Rhonda forgot that baby. You heard from Stacey Pascal. She thoroughly vetted Rhonda before she hired her. She talked to people she worked with. They told her, if there is any babysitter that you want, Rhonda's the one. Brooke Page and Justice Page knew Rhonda. They were tight, close friends. They had known her for years. They had seen her interact with the other kids that she nannied. They had seen her interact with Araya. They trusted her with Araya because she had never given them any reason to doubt the care that she would provide. So the only way that this makes sense is that she forgot the child. If the text message had triggered her memory, she would have gone and gotten Araya out of the car. And I wish that had happened because we wouldn't be here today. But it didn't because she forgot. As we said, culpable negligence is consciously doing an act or following a course of conduct. The only course of conduct that you have heard today is that Rhonda was a good babysitter and exercised great care for the children that she took care of. She engaged with them. She played with them. She got down on the floor in their level and had a good time with them. She wasn't one of those babysitters who sat on her phone all of the time and let them just run and play. That's not what's been testified here today, too. Now, the jury instructions also say that neglect or negligence can be caused by a single incident or repeated conduct. But remember, the state doesn't just have to show neglect, they have to show culpable neglect. And in every one of those lesser includeds, and you're going to get a verdict sheet, in every one of these lesser includeds, the state, to prove any of those, has to prove culpable negligence. And I submit to you, they have not. And that culpable negligence is defined the same way across the course of all of those charges. Now, the state seems to suggest, as we've said, that this doesn't make sense. It doesn't make sense. It doesn't make sense. I'm not sure if the state is trying to imply that Rhonda left the baby in the car on purpose, which I would submit to you makes absolutely no sense. You heard her testimony on the screen that she usually picked the baby up immediately and walked in the house with her. There was no evidence that she would leave the baby in the car if the baby was asleep and go back and get her later on a repeated basis. That was not presented to you. So I'm not quite sure where the state is going with this. It doesn't make sense. Because again, the only way that it makes sense is that she forgot her. And what are the factors that show that that Rhonda truly forgot this baby? What actually triggered Rhonda to remember that Araya was in the car? I submit to you that based on what Rhonda testified to, it was the money that was in Brooke's hand. When Brooke walked in that door with the money in her hand, Rhonda remembered that she was supposed to have had the baby that day. And at that point, she shoves Brooke to the side, takes off running to that car, screaming Brooke's name over and over again. Screaming her name, urinating on herself as she runs to that car to get the baby out just as quickly as she can. She is so frantic that when Brooke asked her to call 911, she had to go back and find her phone and couldn't remember the code to get into the phone. Ladies and gentlemen, you can't fake those kinds of responses. She had forgotten Araya. She had forgotten that she had her. Further, she repeatedly told Stacy as she called her, or told her when she called her, I forgot the baby. But Stacy Pascal testified to you guys that she was so upset that she was screaming and crying and so distraught that she could barely understand what she was saying. And she had to ask her to repeat herself. And all Rhonda could say was, I forgot the baby, come home. And you also have the testimony from Stacy saying that when she got home and made it to Rhonda, Rhonda physically got sick and vomited and was dry heaving in the bushes. You can't fake those. Those are all indicators that Rhonda truly forgot this baby was in the car. Now, we heard from Dr. Cahill today, and he talked about memory. We all know that people forget things. We've all done it. And he named that failure to remember things that you're supposed to do in the future as prospective memory error, meaning you forgot to do what you were supposed to do in the future. And he talked about the fact that there were several things in our lives that can contribute to those kind of errors. Multitasking, divided attention, stress, rushing, lack of retrieval cues, and sleep. I think I got them all. And the only one that he said that was not present in this case was sleep issues. Every other one of those factors was involved. And one of those factors, any one of them by themselves, can affect your ability to remember things. But when you start piling them on top of one another, it greatly increases the likelihood that you're going to have a prospective memory error. Now, the state may say, well, you can remember everything else, but you forgot the baby. Well, that's the only answer that makes sense, because we know that when we forget to do things in our lives, we don't forget other things. If we forget to stop and get something at the store, we don't forget how to drive. There's not a total amnesia there. That's the way the brain works. It's a prospective memory error. And the state wants to make a big deal about Rhonda saying maybe she forgot the baby at the Burger King. That's when she had forgotten that she was there. Or maybe it was when she got to Stacy's. I submit to you, think back to the questions that the state was asking Rhonda yesterday on the stand and how they were asking the questions. They were pressuring her. They were rushing her. And I submit to you, she doesn't know at what point she lost awareness of the baby or forgot the baby. If she knew that, she would have remembered the baby. The state wants to say that there's no way you can forget a child within this 15-minute period or window. And generally, Dr. Cahill said, the longer or the shorter the period of retrieval, the better chance you have of remembering it, as opposed to if it's a longer period, if everything else is equal. But in this situation, we've got habit changes that are going on. We've got Rhonda arriving at Brooke's house earlier than usual. She's pressured to be at Stacy's house on time. She wants to make sure she's on time. It's not holding her up. You have the other things that are going on in her life and the other stress events. And yes, everyone has stress. This was an unusual amount of stress for her because there were big things that were happening in her family. And you heard Rhonda say, that's not an excuse. That's not an excuse. And it's not an excuse, but it does explain to you why prospective memory errors happen. It explains to you why Rhonda forgot. You've got this multitude of, I'm rushing, I've got to be here earlier than usual, I'm multitasking, I'm already thinking ahead as I'm driving about my day, or rather Rhonda's thinking ahead as she's driving about her day. She's thinking, hey, I'm going to have the twins and big sister. I should stop and get them breakfast. Oh, let me look at Burger King. The line is too long. She doesn't have time to do that. So she's distracted by all of these things, and she's planning ahead and trying to keep all of the balls in the air that she's juggling. And somewhere within that drive, she forgets that Araya is in the car. It's clear from the testimony, both yesterday and from the video, that Araya was not making noise. She was quiet in the car. So Araya's not making any noise to make herself known, to trigger Rhonda that Araya's back there. The lack of retrieval cues is important, and the multitasking and divided attention is important because not only is it happening in the car before Rhonda gets to Stacy's, those things continue to happen as the day progresses. So in the car, we just described, Rhonda's thinking about breakfast and getting to Stacy's on time and all of those things. All of Araya's belongings are in the back floorboard of this car. Her baby blanket is in the car seat with her. She is rear facing. Brooke testified that she's the person who put Araya in the car. She put the baby bag in the floor of the car. I submit to you that the lack of hands-on putting in the car by Rhonda Jewell suggests that she would need a stronger retrieval cue to remember the baby. And there's nothing up front. The state's probably going to try to make a big deal about the fact, well, Rhonda remembered her cell phone. She remembered her lunch, and she remembered her cup, and she took that in the house with her. All of those items were in the console area, generally immediately in her point of view and within reach. And she grabbed those things and got out of the car. Everything related to Araya is quiet. Lack of retrieval cues. Then when she gets inside, she's immediately taking care of 3 other children. She's playing with them. She's watching things on her phone. She's engaging with them. She's cooking them breakfast. She's cooking them lunch. And there's nothing of Araya's inside the house. Nothing to remind her of Araya. The state brings up the text messages and says, well, these should have been retrieval cues. Well, Dr. Cahill gave you an example of that. And he said, well, if Brooke and Rhonda only had this relationship of babysitter, employee, and employer, yes, the text message might have been enough to trigger Rhonda's memory and make her remember that she has forgotten Araya in the car. But that's not what we have here. These families were tight. They spent dinners together. They spent vacations and big events together. Rhonda and Brooke Page texted or talked on a daily basis. And Rhonda did the same with Nevaeh Carter. They were like her family. They communicated on a daily basis about things far different and far separate from Araya. And you've seen the content of those text messages just left. And that was a continuation of a conversation that had started before that, in which Rhonda had been talking to Brooke, her friend, about her frustration sometimes with Stacey asking her to come early and then Stacey Pascal not leaving whenever she asked her to do so. Nothing in those text messages mentions Araya. There's no asking about Araya. Nothing in the conversation would trigger Rhonda to remember Araya because of that close relationship that they had and the fact that they communicated all the time. That's what Dr. Cahill was trying to say today. Also important to remember is the change in routine. So clearly Rhonda started keeping Stacey Pascal's twins in, I think, March, April of 2023. Again, if you remember that date, that time frame differently, sorry for allowing your memory. She's keeping the boys 3-4 days a week. Fast forward to May, early June, Rhonda then starts to keep Araya. And at that point, she's keeping the twins and Araya on Mondays, Wednesdays, and Thursdays. Fast forward 2 to 4 weeks from that, and the schedule has changed again. So we are now maybe middle of June, early July, and Araya is now coming back, and their days are backing down. Her grandmother's going to keep her on Thursdays. So Rhonda has Araya and the twins on Monday and Wednesday, and then has the twins by themselves on Thursday. And every time she has the twins and Araya at the same time, they're going to Stacey's house. But there are times when she doesn't have Araya, like Thursdays, so she only has the twins at that house. And then you heard in the couple of weeks leading up to July 19th, specifically if you backtrack to Monday the 17th, Rhonda didn't have the twins. The schedule had changed again. The twins' dad was now working night shift, and so they had backed her down to Wednesdays and Thursdays. So you've got Araya with Rhonda on Mondays, not at Stacey's house, and they're running errands. You've got Araya on Thursdays, Rhonda on Thursdays, just keeping the twins. And then I think even if you back it up, so you've got the 19th when this unfortunate incident happened, you've got a schedule change on that day with we got to be early. The Monday before that, there's a schedule change. It's just Araya. The Wednesday before that, it was testified that there was a schedule change and it was just Araya. And that Thursday before would have been just the twins. So you have all of these changes going on in a short period of time, in addition on top of all of these other factors. And again, multitasking divided attention by itself could lead to prospective memory errors. Lack of retrieval cues by itself can lead to errors. Changes in the routine can lead to errors. But when you put all of those together, you've got a perfect storm and a more likely than not, an even greater likelihood of this prospective memory error. And one of the things that you heard Dr. Cahill say is that when people look at things and stuff happens, we as people are more likely to attribute negative character traits to something somebody else does to us than consider those negative character traits as opposed to environmental factors. Like you gave the example, you're driving and someone cuts you off. Your immediate reaction is to think, oh, that person's a jerk. You know, you're not going to give them any benefit of the doubt. But if you had cut someone off, then you're more likely to think, what's going on here? You know, I got to get to the hospital. I'm in a hurry, such and such and such and such. So the reason that's important is because people in general, I think Dr. Cahill said or testified to, they question, Ms. Johnson, how can you forget a baby in a car? A baby is not a gallon of milk at the store. It's a super important thing. But that brings up the conversation that Dr. Cahill had with you. Prospective memory errors lead sometimes to catastrophic results. He told you about the study with the airplane crashes. I think he said 74 out of 75 airplane crashes were related to prospective memory errors. Just because it's something really important doesn't mean that your brain won't forget it. It doesn't mean that you can't forget. Dr. Cahill was honest. He said, I can't say definitely that Rhonda Jewell had a prospective memory error or not. I'm not in her brain. But what he did tell you was that all of those factors that we just got through talking about make it more likely than not that she would have had a prospective memory error. And that those factors support what she told you, which was that she forgot the baby. And how do we know that the error actually occurred? Because she didn't get the baby out of the car. Had she remembered Araya, she would have grabbed the car seat, taken her inside, and played with her and loved on her all day long. She was a good nanny, and she loved Araya. So again, you might think about, again, Ms. Johnson, how do we forget a baby? You heard Dr. Coyne, the medical examiner, say he's dealt with about 4 hot car deaths over the course of his career. So they're not super common, but they do happen. Even Brad Doherty on the video interview of Miss Jewell says it's possible to forget things, even a child. It's possible to forget things, even a child. And Dr. Coyne also testified that even though he's only had 4, that he's had to deal with post-death investigations, autopsies related to in his career, he said they still happen every summer. And he also said that they can happen even in milder conditions when the temperature is not the middle of July. And I submit to you that if this were not a more common occurrence, if it were not a problem, the new cars that you buy wouldn't have those car sensors in them that say, check the rear seats when you get out of the car. They don't put those things in vehicles because one child dies. It happens. It's a tragedy, but Rhonda forgot the baby in her car. It is not a crime. When you look at counts 2 and 3 in this situation, count 3 is the charge of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm. And that requires the state to prove that Rhonda Jewell was a person responsible for Araya. Araya was less than 6 years of age. And Rhonda Jewell left Araya Page in the car for a period of more than 15 minutes. Rhonda didn't leave that child there. She forgot the child. Leaving implies that you intend to come back. Rhonda forgot the baby. And I submit to you, and as the state I think has indicated, that if you don't believe the state has proven count 3, that she left the baby, which she didn't because it was an accident, she forgot, then you can't find Rhonda guilty of count 2, the 3rd-degree murder. Now, the state seemed to suggest that if you found her guilty of count 3, you had to find her guilty of count 2. That's not what the jury instructions will tell you. They will tell you that you have to analyze 3 first, and only if you think that there's been proven beyond a reasonable doubt on 3 do you even get to 2. But then you still have to weigh that situation independently. Now, as we've stated multiple times, it's your job to weigh the evidence and determine what has been proven beyond a reasonable doubt. And the court's going to instruct you about what reasonable doubt is. And it's some of what it will say is that a reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. I submit to you, ladies and gentlemen, that there is a lack of evidence in this case to prove that Rhonda Jewell did a conscious act. She didn't do anything on purpose. She forgot the baby. And it's your job to hold the state to that burden of proof and require them to prove the culpable negligence. It's not just mere negligence, it's culpable negligence, which is a much higher standard that we have talked about ad nauseum now, so I'm not going back through that again. The state brought up their school bus picture. And the state says, well, if I give you most of this picture, you can figure out it's a school bus. You should still be able to find guilt beyond a reasonable doubt, even if parts of this puzzle are missing. Ladies and gentlemen of the jury, the state has failed to prove that a crime occurred. They failed to prove the meat of the situation, which is that there was culpable negligence. The whole school bus is missing. There's not proof beyond a reasonable doubt here. The other thing that the state says doesn't make sense is this phone call with Brooke at the door. So Brooke said she knocked. Nobody came. I think Rhonda Jewell explained. We were in the kitchen singing, never heard a knock on the door. Brooke tried to use the doorbell. Stacey Pascal says doorbell didn't work. And then Brooke calls. The state tries to make this seem as though it's suspicious or something's going on. There's nothing going on except for Rhonda is taking care of the twins that are in the house and doing what she's supposed to be doing related to them and feeding them and doing those things. And they're having a good time and they're singing, right? There's nothing suspicious going on there. And then the other trigger that makes you know that Rhonda forgot is that when Brooke called her, she's asking Brooke, where are you? What door are you at? Something to that effect. And you saw Rhonda Jewell yesterday. She testified about that, and she was like, I was confused. Like, why are you here? What's going on? That phone call still did not trigger her that she had a riot. And again, it goes back to the fact that they talked all the time. So when Brooke is saying, I'm here, that's why she's like, where are you? What door are you at? She's confused. It's not until she sees the money in her hand that is usually payment for her services that she remembered that she had a riot. just a moment. Ladies and gentlemen, I'm going to play a portion of Rhonda's interview with Brad Doherty again, and Mr. Nelson's going to help me set that up. And I'm actually going to try to put these speakers closer to you, because you heard Mr. Yazdia say that there was a portion of this interview that is not, you can't hear it, that it's unintelligible. I submit to you that you can, because what the state's trying to do is they're trying to say that in this interview, that Rhonda says she was asleep. They're trying to use that to make you guys believe that Rhonda knew the baby was asleep and that that's why she left her in the car. They haven't flat out said that, but I think that's where they're going. And I submit to you that that's.
Your
not
Honor,
what
the
she
state
said.
objects to the characterization of what she thinks I'm trying to do.
Sustain.
Sorry. I believe that the evidence, the state may portray the evidence as though that the baby was asleep and that that's why Rhonda left the baby in the car. I submit to you that that is not what this recording says. And so I'm going to replay it. We can start at 2 minutes and 32 seconds. Detective Doherty said that Rhonda said that the baby was sleeping in the car, but that's not what she said. And so I'm going to play this for you. And remember, you can watch this video again if you need to. I'm going to fast forward to 2 minutes and 32 seconds. We're at 2 minutes, 24 seconds, assuming the computer does what it's supposed to do. It helps if we plug it in.
Too long, so I went to the job I was at on the stage. So I'm out there at 8:15, and the baby was she was asleep, and she was quiet.
She says, I got there at 8:15. The baby was, I guess she was asleep. She was quiet. And again, if you heard something different, I rely on your memory. And then she says, because I don't keep her every day, I forgot she was there. So it's not that she's saying the baby was asleep, so I purposefully left her in the car. She's saying, I guess she was asleep. She was quiet. Now, the state talked about Rhonda's demeanor as she talked to you today and her demeanor in this interview. You've also had an opportunity to hear about her demeanor from Stacy Pascal. You had the opportunity to hear from her demeanor about Brad Doherty. You had the opportunity to briefly see her on that body cam footage as she's coming out of the garage as the officer is going in. Clearly, from those accounts, Rhonda Jewell was distraught, very upset. Stacy indicated that she vomited, that she was dry heaving, that she was screaming and so distraught that she could barely understand her. And in the course of that, she had urinated on herself. This interview happens an hour and a half later, and Detective Doherty says that Miss Jewell has significantly calmed down by that point, but you can still hear and see the emotion on her and in her voice as she talks. And you could see and hear it yesterday. So please take into consideration all of those things when you're thinking about her demeanor, for whatever her demeanor is worth to you. But I submit to you that her demeanor is that of a person who forgot a child in a car. She forgot the child. She didn't think the baby was sleeping and leave there. When you fast forward in that interview and the part that the state played earlier, Brad Doherty circles back around to Rhonda and asks her, and she says, "I assume she was sleeping." You heard Dr. Cahill testify today that the fact that Miss Jewell remembers all of the other time frames and things that are going on this day, but didn't remember Araya, doesn't make her memory bad. It doesn't make her be untruthful. What happens is she's had to recount this story to multiple people, attorneys, the sheriff's office, friends, family, through this last year and a half since this case happened. And you also heard her words. "I forgot the baby. I forgot the baby. How could this have happened?" I submit to you that she spent the last hour and a half before this video interview going through her head, how could this have happened? How could this have happened? So when she says, I assume she was sleeping, she wasn't making noise, she's not saying, "Oh yeah, I left her in the car because she was asleep." She's saying, "I forgot she was there and she was quiet, and that's part of why I forgot that she was there." Again, I submit to you that that's not an inconsistency as the way the state would want to say it is. Rather, it's a person being interviewed an hour and a half after an extremely emotional event that was tragic to her, the death of a child that she loved. The state is correct when it says that in these jury instructions, you will never see the word prospective memory. You'll never see, did she forget? Prospective memory is just a fancy way of saying that you have to remember something in the future. And a prospective memory error is just saying that you forgot to do that. You forgot to remember the thing that you were supposed to remember to do in the future. Again, what these jury instructions say is that the state has to prove that Rhonda Jewell did a conscious act or consciously chose to follow a course of conduct that she knew or should have known was likely to cause death. I forgot does not mean a conscious choice. It means I forgot. There was no conscious choice that was made. And the state didn't call any doctor to refute Dr. Cahill's testimony.
Objection, Your Honor. If we can approach briefly.
Right.
state brought up the example of a driver's duty of care, and that you all agreed that a driver has the duty to exercise care to both themselves and to the other public surrounding. And he brought up the fact that if the driver's texting and causes an accident, the driver should be held responsible for what they did. This driving example is not in any way related or akin to what we have here. If a person is driving and chooses to text, that's a conscious choice. They have consciously chosen to violate whatever duty of care there is there. And then again, the jury would have to decide, was that culpable negligence? In this situation, again, there was no conscious choice. Just like going back to those lifeguard examples that the state used in jury selection, and the state was talking again about the duty of care and violating that was negligence. Well, again, I think the examples that were used were the lifeguard falling asleep, or the lifeguard, reading a book or being otherwise distracted and not doing their job. This, again, is not that case. In that situation, the lifeguard was consciously doing something or making a choice, whereas in our situation, that is not the case with Rhonda Jewell. And B, again, even in that situation, if you went back to the lifeguard, you have to look at whether it's culpable negligence. Again, the results do not determine whether culpable negligence occurred. You have to look at the negligent act itself and determine whether that was a consciously done act or a consciously chosen course of conduct. And I submit to you that it was not. This was a mistake. This was an error. It was a memory error that Dr. Cahill said could happen to anyone, and does. These sorts of memory errors, the failure to remember to do something in the future, does happen to anyone. And unfortunately, sometimes those results are catastrophic. This is a tragedy. It is a horribly sad situation, but it is not a crime. Again, it's human nature to want to hold someone accountable, but you have to apply the facts that have been proven to the law that is given in making your decision. And the defense submits that after you do that, that the state will have failed to prove culpable negligence beyond a reasonable doubt, will have failed to prove that Rhonda Jewell made a conscious act or decision to leave Araya in the car, and that this was simply a horrible mistake, a horrible lapse of memory. And so we are asking you to find her not guilty on count 1. We're also asking you to find her not guilty on count 3, because she did not leave the child in the car. She forgot the child in the car. And as such, you can't find her guilty of count 2, the murder that is predicated on count 2. Again, I thank you for your time, and we appreciate you. Thank you.
May it please the court, Your Honor?
You may proceed. Yes, sir.
Thank you, Judge. The defense kept on saying, this is an accident and this is a mistake. Brooke in Justice on July 19th gave a perfectly healthy baby, Araya, to this defendant to care for, who made an agreement that she would care for her. 5 hours later, Araya is dead. This isn't a mistake. It isn't an accident. I had mentioned before that you will not see the word forget or I forgot or prospective memory error in the jury instructions, and you won't. The defense keeps on saying she forgot. As I said before, and I'll say it again, there are still consequences for your actions. One should still be held responsible as to why Araya is dead. Next, it seems to be my fault. I pressured her when I was asking her questions yesterday. And so as she was admitting to things, it suggested that I pressured her to answer them that way. So I guess it's my fault at this point. Next, we talk about a change in routine because it wasn't normal that she would pick Araya up on that day or Stacy's kids on that day. So we're going to say it's a change in routine. That's why Araya is dead. I could go down the list of reasons that were given. There is one reason why Araya is dead, because she failed in her duty to care for her. Call it a mistake, it isn't a mistake. Say she forgot, that doesn't justify what she did. It isn't an excuse for what she did. Araya is dead because of...
May we approach?
We keep on talking about the word culpable negligence. I'm going to read part of it again. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause the death of the victim in this case. This defendant engaged in a course of conduct that she should have known would cause the death of Araya. It's that plain and simple. And as I said last time, every person has the duty to act reasonably towards others. If they violate that duty without a conscious intent to harm, there's still negligence. They still violated it. So it's a course of conduct or consciously doing something. I don't have to show both.
Your Honor, objection, may we approach again?
No, sit down, please. Have a seat. You can make your argument from there. What is your argument?
My argument is that the state's mischaracterizing the law and discussing negligence instead of explaining culpable negligence to the jury.
Your response?
I am actually reading, Your Honor, from
The instructions.
that are part of the jury instructions.
I think the problem is not giving the entire context of that sentence, Your Honor.
Okay, the jury will note that he's only reading a portion of the definition. I will read the entire definition to you and you will have that definition later. But he's making a point apparently with respect to that. Carry on, sir.
Thank you, Your Honor. Defense had mentioned about gross and flagrant. That is also part of the definition of culpable negligence. If the death of a 10-month-old child who's been left in a vehicle for 5 hours isn't gross and flagrant, the state doesn't know what would be considered gross and flagrant. This is gross and flagrant. This shows a reckless disregard of human life. Also part of the definition of culpable negligence that the court will read to you. It must be gross and flagrant. It must show a reckless disregard of human life and for the safety of other people, including Araya's safety. That's part of the definition of culpable negligence. The court will read to you the entire definition and listen to the entire thing because it fits. what the defendant did is completely culpable negligence. It satisfies count one completely. Something else that the defense mentioned. The defense mentioned the child probably died in 20 or 30 minutes. The child is dead. Whether the child died in 20 or 30 minutes or 4 hours, Araya is dead. Does it make it better that it's in 20 or 30 minutes? Does that somehow excuse this behavior? Araya was in a hot car. What we know is her temperature went up to at least 133 degrees because the car went up to 133 degrees. Her brain was swelling, her organs stopped working, and she died. Whether it's 20 or 30 minutes, or 1 hour, or 2 hours, or 5 hours, the point is Araya is dead. The course of conduct, some of the things that we can point to is the defendant had a duty here. The defendant drove to Brooke's house. The defendant was present when Brooke put Araya in there, in the baby bag in the car. There is a course of conduct here. The defendant then went to Burger King and decided to leave. Her next course of conduct was to go to Stacy's house. Her next conduct was to get out of the car with all these items, except for the baby. There is a course of conduct here where she knew or should have known that Araya was in the car. Something else the defense mentioned about the defendant remembered when Brooke was at the door and had money in her hand. Please go with your memory. The defendant said Brooke had money in her hand. The state doesn't remember Brooke ever saying anything like that. Go with your memory, but the state does not remember Brooke testifying to that. Defense also mentioned about the defendant urinating on herself, vomiting. There could be a lot of reasons for that. One of them is because a child was in her care and the child is now dead. Forgetting a child in a car is not a defense or an excuse for this. Saying it's an accident or accidents happen. I am sorry. I promised you I would take care of your child, and I forgot. Child's dead. It doesn't work that way. There are repercussions for something that drastic when something like that happens. Defense mentioned a few times that the defendant and the victim's family, I believe, were very close. That has nothing to do with this case. Has nothing to do with this case, has nothing to do with July 19th. The fact is, yeah, I guess they knew the defendant, but she didn't care for Araya, meaning she didn't take care of her on July 19th. I said, and the defense agreed with me on this, you will never see prospective memory error on the jury instructions. It's not there. You are still held responsible, and there are still consequences. The defense mentioned, and I'm going to repeat it, that Dr. Cahill says he doesn't even know if the defendant suffered from prospective memory error. He can't even say that she had this. He has no clue. He's just telling you what it is. She may not even have suffered from this thing called prospective memory error, which is a fancy way of saying people forget things. The defense mentioned she didn't, this is semantics. The defense said she didn't leave the child in the car. She forgot the child in the car. Look, count 3 is very clear. I don't need to prove intent. And the state has made it very clear On count one, we're saying culpable negligence. We're not saying intent. I don't need to prove she intended to do anything. Count two, I was very specific to say third degree felony murder, not premeditated. And what the state means by that is we're not saying she meant to do it. We're not saying she intended to do it. And then count three, the same thing. I don't need to prove any intent, and I've never alleged she intended to do it. But we're not going to play word games here and say leaving is not the same as forgetting. She didn't leave the child in the car for 5 hours. She forgot the child in the car for 5 hours. The statute is clear. If you leave a child in a car for 5 hours, unsupervised, over 15 minutes, and something bad happens, you're guilty. She left the child in a car. I'll just very briefly say that defense had talked about her demeanor on the video. I'm going to ask you to judge her demeanor. It's been an hour and a half, which to the state that isn't a lot of time. An hour and a half later, she's giving an interview. You judge her demeanor. An hour and a half after she realized that a child in her care is now dead. Prospective memory error. Do you need to remember to care for a child when you pick them up from the parent's house? Ms. Johnson mentioned about my driving example, that you make a conscious decision to drive. She made a conscious decision to care for Araya. She was getting paid money. She picked her up on certain days. She drove there that day. She had Araya put in the car, the baby bag put in the car. She made a decision to care for Araya on that day, and she didn't. Once again, when you go back into that jury room, look at all the evidence. I've put some evidence on, the defense has put some evidence on. You as jurors have to look at everything, not just the state's evidence, the defense evidence as well. We are asking you for count one to find her guilty of aggravated manslaughter of a child. Araya is dead because of her culpable negligence. Then for count three, I like to switch it, leading a child in a car for over 15 minutes, resulting in death. She's guilty of it. And once again, we're not saying she did this on purpose. That doesn't matter here. We're not arguing intent. And then for number two, third degree felony murder, not premeditated, because the felony she committed was leaving the child in the car for over 15 minutes, 5 hours actually, and the child died because of her actions or inactions for not caring for that child. So once again, I ask you to find her guilty on all three counts. Thank you.
Members of the jury, we have some rather lengthy jury instructions that I'm going to have to read to you. So before we do that, we're going to go ahead and take about a 15-minute recess so you can stand up, stretch, and be ready for the instructions. So we are in recess. The term motor vehicle means a self-propelled vehicle not operated on rails or guideways, but not a bicycle, electric bicycle, motorized scooter, electric personal assistive mobility device, mobile carrier, personal delivery device, swamp buggy, or moped. I need to tell you that you may want to refer to these definitions as you read through the instructions in considering your verdict. To prove the crime of aggravated manslaughter of a child, the state must prove the following three elements beyond a reasonable doubt. One, Uriah Page is dead. Two, the death of Uriah Page was caused by the culpable negligence of Rhonda Jewell. And three, Uriah Page was at the time a child, and her death was caused by the neglect of Rhonda Jewell, a caregiver for Uriah Page. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of merely negligent act. But culpable negligence is more than the failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to the intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. And again, culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Neglect may be based on repeated conduct or on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical injury or a substantial risk of death to the child. In considering the evidence with regard to count one, which charges manslaughter of a child, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of aggravated manslaughter of a child, of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes for aggravated manslaughter of a child are: 1, manslaughter; 2, neglect by culpable negligence of a child causing great bodily harm, permanent disability, or permanent disfigurement; and 3, neglect by culpable negligence of a child without causing great bodily harm, permanent disability, or permanent disfigurement. The fourth lesser included offense is culpable negligence inflicting injury, and the fifth lesser included is culpable negligence exposing another to injury. I will now instruct you on these lesser included offenses. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Araya Page is dead. 2, the death of Araya Page was caused by the culpable negligence of Rhonda Jewell. Again, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if a negligent act, period. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. The next lesser included offense with regard to count 1 is neglect of a child with great bodily harm, permanent disability, or permanent disfigurement. To prove the crime of neglect of a child causing great bodily harm, permanent disability, or permanent disfigurement, the state must prove the following 4 elements beyond a reasonable doubt. 1, Rhonda Jewell, by culpable negligence, failed or omitted to provide Araya Page with the care, supervision, and services necessary to maintain Araya Page's physical or mental health. 2, in so doing, Rhonda Jewell caused great bodily harm, permanent disability, permanent disfigurement to Araya Page. Number 3, Rhonda Jewell was a caregiver for Araya Page. And number 4, Araya Page was under the age of 18 years. Neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. Continuing with lesser included offense, the next one is neglect of a child without great bodily harm, permanent disability, or permanent disfigurement. To prove the crime of neglect of a child, the state must prove the following 3 elements beyond a reasonable doubt. 1, that Rhonda Jewell was, by culpable negligence, failed or omitted to provide Araya Page with the care, supervision, and services necessary to maintain Araya Page's physical or mental health. Number 2, Rhonda Jewell was the caregiver for Araya Page. And number 3, Araya Page was under the age of 18 years. And again, you are instructed that neglect of a child may be based on repeated conduct or on a single incident or omission that resulted in, or reasonably could have been expected to result in, serious physical or mental injury or a substantial risk of death to a child. There is yet another lesser included offense, and this would be culpable negligence inflicting injury. And it is to prove the crime of culpable negligence inflicting injury, the state must prove the following 2 elements beyond a reasonable doubt. 1, Rhonda Jewell inflicted actual personal injury on Araya Page. And number 2, she did so through culpable negligence. And the final lesser included offense in count 1 is culpable negligence exposure to injury. To prove the crime of culpable negligence exposure to injury, the state must prove the following 2 elements beyond a reasonable doubt. 1, Rhonda Jewell exposed Araya Page to personal injury. And 2, she did so through culpable negligence. And in this instance, actual injury is not required. Turning now to count 2 in the information, where the defendant is charged with 3rd-degree felony murder. To prove the crime of third-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. One, Uriah Page is dead. Two, while engaged in the commission of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury, Rhonda Jewell caused the death of Uriah Page. And number three, Rhonda Jewell was the person who actually killed Uriah Page. It is not necessary for the state to prove the killing was perpetrated with a design to effect death. The felony crime of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury is committed when a defendant is a person responsible for a victim. The victim is under the age of 6 years. The defendant leaves a victim unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes. And in so doing, the defendant caused great bodily harm, permanent disability, and or permanent disability to the victim. In reference again to count 2, where the main charge is third-degree felony murder, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of third-degree felony murder, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime for third-degree felony murder is manslaughter. I will now instruct you on the elements of the lesser included offense of manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Uriah Page is dead. 2, the death of Uriah Page was caused by the culpable negligence of Rhonda Jewell. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. Turning now to count 3 in the information, which charges the defendant with leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury, the state must prove the following 4 elements beyond a reasonable doubt. 1, Rhonda Jewell was a person responsible for Uriah Page. 2, Uriah Page was younger than 6 years of age. 3, Rhonda Jewell left Uriah Page unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes. And 4, in so doing, Rhonda Jewell caused great bodily harm, permanent disability, and or permanent disfigurement to Uriah Page. With respect to lesser included offenses with regard to count 3, in considering the evidence, you should consider the possibility that also the evidence may not convince you that the defendant committed the main crime of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury. There may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, If you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime of leaving a child unattended or unsupervised in a motor vehicle with great bodily injury is leaving a child unattended or unsupervised in a motor vehicle, excluding the great bodily injury portion of it. I will now instruct you on the elements of that lesser offense. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle, the state must prove the following three elements beyond a reasonable doubt. One, Rhonda Jewell is a person responsible for Araya Page. Two, Araya Page was younger than 6 years of age. And three, Rhonda Jewell left Araya Page unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. That presumption stays with the defendant as to each material allegation in the information and through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged and that was committed. I'll read that over. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, nor a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having such a conviction, it's one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced at this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, then you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things that you should consider are: one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Two, did the witness seem to have an accurate memory? Three, was the witness honest and straightforward in answering the attorney's questions? Four, did the witness have some interest in how the case should be decided? Five, does the witness's testimony agree with the other testimony and other evidence in the case? And six, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside the court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain that it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some of the rules that apply to your discussions and deliberations. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it's set out in these instructions. If you fail to follow the law, your verdict would be a miscarriage of justice. There is no reason for failing to follow the law in this case, and all of us are depending upon you to make a wise and legal decision. Number 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions of law. Number 3, the case must not be decided for or against anyone because you feel sorry or are angry at anyone. Number 4, you should remember that the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way, so please disregard anything that I may have said or done during the course of this trial that makes you think I prefer verdict over the other. You may find the defendant guilty as charged or guilty of such other lesser included crime as the evidence may justify, or find the defendant not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Your verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary form of verdict has been prepared for you, and at this time, I will go over the verdict for you. Realizing that you can't read it from here, I'm going to omit what we call the formal portion up top, and it says, we'll start here with verdict. It says, we, the jury, find as follows as to count one of the information. And there's an instruction in parentheses that says, select only one. Then you will have 7 possible choices. You need to select one of those. Number 1, the defendant is guilty of aggravated manslaughter of a child as charged in the information. Number 2, the defendant is guilty of manslaughter, a lesser included offense of aggravated manslaughter of a child as charged in the information. Number 3 choice, the defendant is guilty of neglect by culpable negligence of a child causing great bodily harm, permanent disability, or permanent disfigurement, a lesser included offense of aggravated manslaughter of a child as charged in the information. Your 4th choice will be the defendant is guilty of neglect by culpable negligence of a child without causing great bodily harm, permanent disability, or permanent disfigurement, a lesser included offense of aggravated manslaughter of the child as charged in the information. Your 5th choice will be the defendant is guilty of culpable negligence inflicting injury, a lesser included offense of aggravated manslaughter of a child as charged in the information. Your 6th choice is the defendant is guilty of culpable negligence, exposure to injury, a lesser included offense of aggravated manslaughter of a child as charged in the information. Number 7 is the defendant is not guilty. The form continues, we, the jury, find as follows as to count 2 of the information, and then there in parentheses, there's an instruction, select only one. This time you will have 3 choices. Choice number 1, the defendant is guilty of 3rd-degree murder as charged in the information. Choice number 2, the defendant is guilty of manslaughter, a lesser included offense of 3rd-degree murder as charged in the information. And choice number 3, the defendant is not guilty. Continuing, we, the jury, find as follows as to count 3 of the information. And again, parentheses, select only one, that instruction. You will have 3 choices. Choice 1, the defendant is guilty of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury as charged in the information. Choice number 2, the defendant is guilty of leaving a child unattended or unsupervised in a motor vehicle, which is a lesser included offense of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury as charged in the information. And your 3rd choice is the defendant is not guilty. Then, signifying that your verdict is unanimous, it says, so say we all, this blank day of November 2024 at McClenny, Baker County, Florida. Then there is a signature line for the 4-person, and beneath that, it says 4-person printed. So the 4-person should print his or her name there. Counts 2 and 3 are linked in that the crime charged in count 3, and that charges leaving a child unattended or unsupervised in a motor vehicle, is an essential element of the crime charged in count 2, which charges third-degree murder. You should first consider the evidence applicable to count 3. If you find the crime in count 3 has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 2 and 3. On the other hand, if you find that the crime charged in count 3 has been proven beyond a reasonable doubt, you must then consider the evidence. Guilty verdict on count 3 does not require a guilty verdict on count 2. You should find the defendant guilty on count 2 only if you find that crime, including the essential elements contained in count 3, were proven beyond a reasonable doubt. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. And except for the situation described in the instruction entitled Legally Interlocking Counts, that's the one I had just read to you, a finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few minutes, you will be taken to the jury room. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your decisions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. Thus, if a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. Many, if not all of you, have cell phones, tablets, or laptops, or other electronic devices here in the courtroom. The rules of court do not allow you to bring your phones or any of those types of electronic devices into the jury room. Please leave these devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. And if you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer, and I will answer any questions, if I can, in writing or orally back here in the courtroom. During the trial, items were received in evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The photographic exhibits and written exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any additional exhibits, including audio and video exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case, and even if you do not like the laws, you still must apply them. For more than 2 centuries, we have lived by the Constitution and the law, and no juror has the right to violate rules that we all share. Speaking to counsel, has the court omitted the giving of any instruction upon which either party relied other than noted in the charge conference?
Other than the charge conference, no, sir.
Fine, Judge.
Okay. Are there any additions or corrections which need to be made with regard to those instructions that were given?
No, sir.
May we approach?
Yes. Shortly, I will excuse our 2 alternate jurors, who is Ms. Gullidge and Mr. Wells, from further participation in the trial. And I realize that being an alternate juror is probably a very frustrating experience, particularly in a case like this, where you have devoted 5 days of your life. And when it comes down to the bottom line here, you're not going to participate in the decision. However, even though you won't participate in the decision-making process, let me assure you that your presence has served a very useful purpose, because I can tell you from doing this for a long time that anytime you have a trial that lasts more than 2, maybe 3 days, typically one of the jurors, one of the 6 jurors, gets sick or has a family emergency, or has to leave for some reason. That's where the alternate comes in handy. The alternate is then plugged into that spot. So you served a very useful purpose, both of you did. And I want to thank you for your participation in the trial. And I'll remind, when the remainder of the jury retires, you will be free to go. But by the same token, if you wish to stay to see what result may come of this, you're certainly free to stay. So again, I thank you for your service as a juror, both of you. Speaking to the remainder of the jury, when you have reached your verdict, or if you need to communicate with me, please knock on the door and inform the bailiff, who will advise me. And as I said earlier, you normally will have to communicate with me in writing. The only exception to that is if you have a verdict and are ready to come back, you can just tell the bailiff we have a verdict, and he will advise me accordingly. Shortly after you enter the jury room, the bailiff will deliver to you the verdict form that I read to you, the exhibits which were received in evidence during this trial, and written copies of these instructions. Altogether, these instructions constitute all of the laws that apply to this case. At this time, you may retire to the jury room to deliberate and consider your verdict.
All right.
Would counsel please,
I think the alternates,
let's make,
alternates went back there.
well, she's probably, make sure the 2 alternates, they may be picking up their personal belongings, but make sure that they come out. How about the exhibits? Have they gone? Okay. Would counsel please approach the clerk's bench and look and make sure what's going in? counsel approach. Do we know where the defense people are? Madam Court Reporter, if you'll let me know when you get where you. It's gonna be 10 to 15 minutes till she gets it. Very good. Be seated, please. Members of the jury, for the record, your request in writing was out. Can we get the court transcript for the defense cross and the state's redirect of Brooke Page? That was the request. The response was that a transcript, a written transcript, is not available, but we will have you return to the courtroom and have the court reporter read back the desired testimony. We agree that that's what we're here for. Okay, Madam Court Reporter, if you are prepared, if you would please do the read back.
Yes, sir. Okay, can everyone hear me okay? Okay, if you can't, just let me know. Okay. And this is a cross-examination of, Brooke Page by Ms. Johnson. Question. Good morning, Ms. Page. Answer. Good morning. Question. I am so very sorry and I offer my condolences for Araya. Answer. Question. You indicated on direct exam that you have known Rhonda Jewell for many years, it sounds like. Is that correct? Answer. Correct. Question. I think specifically your stepdad went to school with her. Answer. I think so, yes. Question. And then my understanding is that your family sort of reunited around 2017 or 2018, whenever your brother, Mrs. Jewell's son, graduated from high school together, correct? Answer. Yes. Question. It sounded like you guys all became very close friends. Answer. Yes. Question. My understanding is that she was really, tight with your family. Answer. Yes. Question. Would that be an accurate way to put that? Answer. Yes. Question. And there were times that you and your husband, Justice Page, spent time with Mrs. Jewell and her husband and her family, correct? Answer. Yes. Question. And I think your parents may have also spent a lot of time with them, correct? Answer. Yes. There's a sidebar conference. Okay, continuing by Ms. Johnson. Question. Ms. Page, as far as the family connection that you all had, there were times that you went to dinner with Rhonda Jewell and her family. Answer. Correct. Question. And I think there were times that you guys went on vacation with Rhonda and her family, correct? Answer. Correct. Question. So you knew Rhonda outside of the babysitting duties that she was performing for you for Araya. Answer. Correct. Question. And you knew before she started keeping Araya for you that she had kept other children, correct? Answer. Correct. Question. And my understanding is that she was actually keeping Stacy Pascal's twins and occasionally her daughter before she started keeping Araya for you. Is that correct? Answer. Correct. Question. And I think my understanding is that she had to ask Stacy if it was okay if she kept Araya on top of her children, correct? Answer. Correct. Question. So it was your understanding that most of the time Rhonda would have Araya at Stacy's house, correct? Answer. Correct. Question. I think you indicated that your babysitter, your cousin, had to quit taking care of Araya for other reasons, and that's when you asked Rhonda to be your babysitter, correct? Answer. Correct. Question. And you said you thought that was around May of 2024 or 2023. Excuse me. I'm sorry. Answer. Correct. Question. Initially, whenever Rhonda started keeping your baby, Araya, my understanding is that she was keeping her more often during the week. Is that correct? Answer. Can you re-ask that question? Question. Sure, it was poorly phrased. I'm sorry. Initially, when Rhonda started keeping Araya, she was keeping her Monday, Wednesday, and Thursdays, or Mondays, Tuesdays, Wednesdays, Thursdays. Do you remember how often she was keeping her originally? Answer. Yes, it was Monday through Thursday. Question. And so generally, she would pick Araya up as you described and then take her to Stacy's house if she had Stacy's children those days. Answer. Correct. Question. During that, there were some days that she didn't actually have Stacy's children, correct? Answer. Correct. Question. So on those days, Rhonda would either keep Araya around town running errands or take her back to her house. Is that correct? Answer. Correct. Question. So you said that she started keeping Araya for you in May. At some point before July 19th, that schedule changed. Is that accurate of the days that Rhonda was keeping Araya? Answer. The schedule changed. Yes. Question. And my understanding is that she began keeping Araya on Mondays and Wednesdays. Is that correct? Answer. Correct. Question. I'm sorry. Was that a yes? Answer. Correct. Question. My understanding is that your mother-in-law, Mrs. Pamela Page, started keeping Araya for you on Tuesday and Thursdays, correct? Answer, correct. Question, so there were times when you went to Stacy Paschal's house to pick Araya up, and there were other times you went to other locations to pick up Araya, correct? Answer, yes, but no. Question, okay, what do you mean, but no? Answer, I mean, hardly ever it was a majority of the time was at Stacy's house. Question, the Monday before July 19th, which was a Wednesday, Rhonda Jewell had Araya on that day, but did not have Stacy's twins, correct? Answer, I do not remember. Question, do you recall picking Araya up from Rhonda at the home of Kaylee and Mike Rogers? Answer, I do. Question, do you recall if that was recently in time to this incident on July 19th? Answer, I remember doing it, but I don't remember exactly when. Question, and there were other occasions where Rhonda had Araya at her own house and someone had to travel that 30-minute drive to pick her up, correct? Answer, correct. Question, we saw some text messages today and you discussed those with Mr. Yazdia. And my understanding is that you would frequently text Rhonda because she was a friend of yours and of your family's, correct? Answer, correct. And you guys would text about life in general, different subjects. Answer, correct. Question, when we saw the text message from 8/17 that said just left or she just left, you testified that you believed that Rhonda was saying that Stacy had just left her house. Answer, correct. Question, there were times that Rhonda would be irritated with Stacy and would vent to you about the fact that she didn't always leave exactly when she said she was going to, correct? Answer, correct. Question, so there were times when Stacy Paschal would tell Rhonda, I need you to come early, I need you to be here early, but then she wouldn't, by Mr. Yazdia, objection, Your Honor, hearsay, by the court response. By Ms. Johnson, my response is it goes to directly what she was saying as to what the text message was related to and how she knew that. By the court is hearsay, we'll allow that one, but let's avoid that. By Ms. Johnson, question. So there were times when Stacy would indicate to be there at a certain time and then would be later leaving. Answer, correct. Question, and Rhonda had discussed that with you? Answer, correct. Question, but because of the family relationship or family life relationship that you had with Rhonda, it wasn't unusual for you to just generally text her, correct? Answer, correct. Question, when you asked Rhonda to be a babysitter or nanny for your daughter, you had no concerns about her ability to give her care, correct? Answer, correct. Question, you felt that Araya was safe with her. Answer, correct. Question, and you hadn't had any incidents up until July 19th that caused you to question that opinion, correct? Answer, correct. Question, you indicated that generally when Rhonda would pick up Araya, you would be on the lookout for her and you would take Araya out to the car, correct? Answer, correct. It sounds like you usually were the one who put Araya in the car. Answer, correct. Question, and you buckled her seatbelt, the car seat into the seat? Answer, correct. Question, and then of course, it's an infant carrier, so Araya's buckled into the harness of the seat as well. Answer, correct. Question, and I think you said you usually put the baby bag on the floor, on the floorboard of the passenger side under the car seat she was in? Answer, correct. Question, usually Rhonda didn't get out of her car for the process? Answer, no, that's not correct. Question, that's not correct? Answer, no. Question, on this day, on July 19th, Rhonda didn't get out of the car? Answer, that's not correct. Question, did Rhonda come to your house on that day? Answer, no. Question, you guys had a brief conversation there while Rhonda's at your house? Answer, yes. Question, and then Rhonda had to leave so she could be on time to get to Stacy's, correct? Answer, yes. Question, when you placed Araya in the car, she had the baby blanket in the car seat with her, correct? Answer, correct. Question, on the days that Rhonda had Araya and she was not keeping Stacy's children, you had no objection to her running errands with her or taking her to other places, correct? Answer, correct. Question, when you asked Rhonda to be a caregiver for Araya, you were familiar with the care that she had given to other children in this capacity. So I'm assuming you felt like she knew what, by Mr. Yazdia, objection, Your Honor, by the court, basis for that is what, and there's a sidebar here. Give me one moment. Okay. And continuing on, by Ms. Johnson, question, Ms. Page, I was simply asking because you were aware of Ms. Jewell being a nanny to other children, you knew that she knew what you were expecting of her when you asked her to take care of Araya, correct? Answer, correct. Question, on this particular day, this was the earliest that Rhonda had ever picked up Araya from you, is that correct? Answer, correct. Question, so she had to be there even earlier than usual? Answer, correct. Question, and then you said that you usually left your house Left your house at 1 to travel to Stacy's house to pick up Araya? Answer, correct. Question, and you did the same thing on this day on July 19th? Answer, correct. Question, you talked about you knocked on the door and no one answered, correct? Answer, correct. At that time, you could hear the kids in the house making noise? Answer, correct. Question, and you could tell the TV was on? Answer, correct. Question, but no one came to the door? Answer, correct. Question, and then you rang the doorbell and no one still came to the door? Answer, correct. So you testified that you called Rhonda? Answer, correct. And you said, I'm here? Answer, correct. And then you said that she asked what door you were at? Answer, correct. Question, it sounds like you thought that was odd that she was asking you that because you always came to the front door? Answer, correct. Question, she stayed on the phone with you the whole time as she's walking through the house to open the door for you, correct? Answer, I don't know where she was at in the house. Question, okay, but she was on the phone with you as she's walking towards the door? Answer, correct. Question, you step inside the door and you said you took off your shoes? Answer, correct. At that time, you had your phone and your keys in your hand? Answer, correct. You also had the money in your hand that you were going to use to pay Ms. Jewell for her babysitting duties, correct? Answer, correct. Question, and you usually would pay her on Wednesday because that would be the end of the work week for you? Answer, correct. Question, and so as you walk into that door and you're taking off your shoes, that's when Ms. Rhonda pushed you to the side and started running out of the door? Answer, correct. And you said she was screaming your name over and over? Answer, correct. Question, so she was just saying, Brooke, Brooke? Answer, correct. Question, and she continued to do that as she ran all the way out of the front door to the vehicle? Answer, correct. Question, did you follow her off the porch or did you not leave the porch until she got to her vehicle? Answer, I followed her off the porch. Question, at some point you dropped your own cell phone and the things that were in your hand, correct? Answer, correct. Question, when you got to the car, you tell Rhonda to call 911, correct? Answer, correct. At that point, Rhonda runs back towards the house, correct? Answer, I don't know where she went. Question, and was it your impression that she was trying to follow your instructions to go call 911? Answer, yes. Question, ultimately, you ended up calling 911? Answer, yes. Question, was that because you just felt like this was taking too long and you needed to make the phone call? Answer, yeah. Question, fair to say that 30 seconds or less happened between you telling Rhonda to call 911 and you made the call yourself? Answer, I honestly don't know. Question, I'm sure your goal at that point was just to get someone there as quickly as possible? Answer, correct. Question, as you're on the phone with 911, Rhonda got Araya out of the car, correct? Answer, correct. And Rhonda's standing there and she's holding Araya? Answer, correct. Question, she's crying? Answer, correct. Question, and she's saying something, but you're not sure what she was saying? Answer, I do not remember. Question, and at some point you tell Rhonda to take Araya inside or into the AC, correct? Answer, correct. And that's when you guys end up in the garage? Answer, correct. Question, when you got to the vehicle and you see Araya there, Araya is still in her car seat, correct? Answer, correct. Question, and her blanket is still in the same general area of where you had left it? Answer, correct. Question, and the baby bag is in the same area where it had been placed by you? Answer, correct. Question, generally, if Araya was not awake in the morning by 7:30, 7:40, you're going to wake her up and get her ready for her day. Is that accurate to say? Answer, yes. Question, sometimes Araya would wake up naturally on her own earlier than that? Answer, sometimes. Question, and sometimes you would have to wake her up? Answer, yes. Question, because you wanted her to be ready when Rhonda came to pick her up, because generally that's going to be a quick exchange, correct? Answer, correct. On this particular day, Araya woke up around 6:30, is that correct? Answer, correct. And that is the conclusion of the cross-examination by Ms. Johnson. And I will read the redirect, one moment. Okay. And this is the redirect examination by Mr. Yazdia of Brook Page. By Mr. Yazdia, question, Ms. Page, follow-up questions. On July 19th of 2023, did the defendant get out of her vehicle when she came to your house to get Araya? Answer, yes. Question, and where did she go when she got out of that vehicle? Answer, she went to the back door of her car to help me strap Araya in. Question, so she was aware that obviously Araya was being put in her vehicle? Answer, yes. Question, and she had been doing this for a while, picking up Araya from your house? Answer, yes. Question, so this wasn't some weird day out of the ordinary where she's just coming by your house to get Araya? Answer, correct. Question, this was something that you had paid her to do, to be the nanny and the babysitter? Answer, correct. Question, when she left once again, Araya and the baby bag were in the car. Answer, correct. Question, and the defendant was driving that car? Answer, correct. Question, is there anyone else in the car? Answer, no. And that is the conclusion of the redirect.
Members of the jury, you may now return back to the jury room to continue your deliberation.
All right.
Okay, we'll be in recess to await the jury's return. has a verdict, is that correct? All right. Just a second, we'll bring them in. Speaking to the audience, shortly the verdict will be read. First, I want to compliment the audience during this entire week. You've been, and each member of the audience, you have been particularly quiet and respectful. That's the way the system is supposed to work. And we do appreciate the way you've conducted yourselves. That being said, I want to caution each of you that there should be no emotional outbursts or comments when the verdict is read. So you've done a good job thus far, so let's keep it that way. At this time, would you show the jury in, please?
All jurors present.
Very good, thank you. Be seated, please. Speaking to the foreperson, has the jury reached a verdict?
Yes, Your Honor.
Would you hand it to the bailiff and he'll hand it up to me? Thank you. Ms. Jewell, would you and your attorneys please stand while the verdict is read? At this time, I'm going to ask the clerk to please publish the verdict.
In the Circuit Court of the 8th Judicial Circuit, in and for Baker County, Florida, State of Florida versus Rhonda Charmane Jewell, case number 02-2023 CF 333. We, the jury, find as follows as to count 1 of the information. The defendant is not guilty. We, the jury, find as follows as to count 2 of the information. The defendant is guilty of third-degree felony murder as charged in the information. We, the jury, find as follows as to count 3 of the information. The defendant is guilty of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury as charged in the information. So say we, this 8th day of November, 2024, at McClenny, Baker County, Florida, signed by the foreperson, David Simmons.
Very good. Be seated, please. Is either counsel aware of any further proceedings that would require the presence of the jury?
We'd like to have the jury polled, Judge.
Okay. Members of the jury, a request has been made that the jury be polled. The purpose of conducting a poll is to verify that the verdict of the jury is unanimous. Shortly, the clerk will be asking each of you individually if the verdict that was just read is your verdict, and you should respond appropriately, yes or no. I remind you that you are still under oath that you took at the commencement of this trial. The clerk will now conduct the poll of the jury.
Juror number 288, is this your verdict?
Yes.
Juror number 48, is this your verdict?
Yes.
Juror number 373, is this your verdict? Yes. Juror number 150, is this your verdict?
Yes.
Juror number 139, is this your verdict?
Yes, ma'am.
Juror number 50, is this your verdict?
Yes.
Very well. Any further proceedings involving the jury?
No, Your Honor.
No, sir. Very well. Members of the jury, I want to thank each of you for your time and consideration. It's been a week and it's been a long week. And I know that a lot of the time you sat around and didn't have much to do, but that's just the process. But without the service of jurors such as yourself, the system would not work. And your participation really is just essential to our jury service. I also want to advise you of some very special privileges enjoyed by jurors, specifically without a court order. No juror can be required to talk about the discussions that occurred in the jury room. And although you're free to speak with anyone about your deliberations, you are also free to refuse to speak to anyone. The lawyers and their representatives are not permitted to initiate any communications with you about the trial. However, you may speak to the lawyers or anyone else about the trial. You also have the right to refuse to speak with anyone. It will be up to you to decide whether to preserve your privacy as a juror. And again, I do seriously thank you for your service as a juror. And with those instructions, you are discharged from further service. Mr. Bailiff, you may want to escort them back to the jury room. They can pick up their personal effects and whatnot, and then you can escort them from the courthouse as you please. So at this time, again, thank you.
All right.
Be seated, please. Mr. Nelson, is your client entitled to a pre-sentence investigation report?
Yes, sir, she is.
Okay. It's my understanding she is out on bond at this time.
She is, Judge.
I'm going to remand her to the custody of the sheriff pending bond, that they're willing to keep her on the bond pending, or at least until such time as we have sentencing.
So we just verified that she can be released?
Yeah, soon as it's been verified, that's how she can be released. Okay, are there any other proceedings in this case at this time that we need to deal with?
You want to set a date, Judge, or how do you want to handle it?
I don't at this point because I don't know what it is. Something will be coming out very soon though, probably first part of next week.
Who do you want to notify probation and parole about the PSI? You want me to
Would
do
you
that?
like to do it?
I'll do that.
Okay, very good. That'll be fine.
Your
Yes.
Honor, Mr. Nelson and I pledge briefly.
Anything else we need to do at this point?
No, sir.
Okay, again, to everyone, thank you very much for your participation in the process, and we are adjourned.
Thank you.
Thank you, Judge.
Yes, sir.
Thank you.